at the end, but the journey and the legal knowledge will always stay with us. Thank you. Also, how long until the jury makes the verdict? It should be hopefully they said
Any
4:30,
any
right?
any moment.
We're
We are
looking for any
waiting.
minute now. Huh?
We are waiting
Yeah.
every moment to see what is going on as we stare at the seal, the great state of Minnesota.
To your opinion, do you think he's guilty? I thought he was. Well, again, he, he can only be guilty under the law, that under the law of the competent jurisdiction. Under the law in Minnesota, right? I think he's guilty under the law in Minnesota. Man
Yeah,
two, and I think they've proven him guilty under the second degree felony murder. But
yeah.
again, that's in Minnesota. That's specifically for Minnesota, though. You know what I'm saying? And how I understand Minnesota to be. What were you going to say, Kurt? I'm sorry.
No, I just completely agree. I did a whole thing on my stream yesterday, going through it legally, going through the elements of it. So, for me, legally in Minnesota, which I say with emphasis because Minnesota weird, but yeah, guilty murder second, not guilty murder third, guilty on manslaughter second is my best conclusion under the laws of the great state of Minnesota.
Yeah, 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 yeah. It seems like YouTube is having some problems too, because now everybody, all these streams are like stopping. But we'll see.
Stopping and starting. Maybe lower the
Yeah.
resolution if it makes any difference. I don't know, because I don't want to be interrupted when they start actually announcing things.
Oh no, no, I got two of them running just in case. So.
Okay, well, thank you.
Yeah. It's
I
not.
don't want to. I don't want to be a
Now,
grumpy on civil law.
so as soon as they start saying something, we're going to be all over it. It doesn't matter. It doesn't matter much if they find him guilty. There is enough for there be appeal. Yeah, there's enough, but having enough for an appeal isn't the same as winning an appeal, right? So appeals
Yeah,
are hard. Appeals aren't easy. There's a lot of people looking for an appeal. So, and you have to kind of figure out, is it, when you're looking at appeal, you have to ask the question: is there enough here that would have overturned the verdict, right, or
yeah,
made it unfair? So that's what you're looking at, right?
yeah.
Oof.
Something of fundamental unfairness, which I haven't seen, of that kind of thing, or some sort of error that would have changed the result. So absent that thing, would it have come out differently? And it's a hard standard, and I don't see it right now given what I can see.
Yeah, it's going to be tough. It's going to be tough. All right, here we go. We got the sun feed up finally. I'm going to switch to the sun's feed. Hold on.
Wonder if Crime Talk is having any better luck.
Crime
Usually
talk.
their feeds, yeah, Crime Talk is usually pretty good on their feed.
Yeah. Hold on. I'm just adding this feed to it.
You know,
The
Crime
sun
Talk,
feed.
he's a pretty interesting guy.
No, no. There's been a lot of lawyers that I've been following on YouTube.
Seen Waters and her comments and
Let me
saying
try this one. Hold
that
on.
may be
Share
enough if there's
audio.
a conviction.
That's our good old. Oh, that's the other one that we had. The one that's not working. Sorry, I'm having my boomer moments now.
The spinning wheel of reloading somehow has a very what's the right word? A very morose interpretation or something, given what we're talking about right now, has a very sort of dark comedy to it about the thing. The spinning wheel of justice here.
Yeah, right. Uh,
Spin, justice wheel, spin.
oh my God. Here we go. So thanks for that. The son's feed is there. Son, innocent. Oh, this person says innocent murder two, or manslaughter, but guilty on felony murder, which is an oxymoron. So hold on. No, well, he can't be innocent of murder two, or manslaughter, but guilty of. It's you. You got it. All right. Murder two is felony murder, so you can't be innocent of murder two and then guilty of felony murder. That's the oxymoron, right?
Yeah.
So yeah. This should say is innocent of third degree murder or manslaughter, but guilty of felony murder. That's what I think you're trying to say. And yeah, I think it's unfortunate, but in Minnesota, let's just be fair. In Minnesota, it's easier to prove an assault than it is to prove manslaughter, and you got to prove an assault for second degree murder. It's not me; it's the legislature up there. Thanks, guys.
Yep.
It's been fun. I hope you both survived the aftermath. That's true. Well, you're in Texas, so I don't think you got to have too many problems.
Well, I'm
there,
in
right?
downtown Austin, so I wouldn't, put money on it.
Oh.
I wouldn't put money on it. I'd just stay
Appeal,
inside.
appeal means wild rioting. But again, we don't. That's assuming he's found guilty, right? people are assuming he's found guilty. We don't know. They could come back and say, hey, he's innocent, right? Or innocent. He's not guilty because we don't do innocence. So
it should go over super well.
So we don't know. Police are closing the gates to their headquarters. This could be an indication of the verdict. It may be, maybe not guilty.
I think they're just prepping either way. Well, I'm in downtown Austin, so
it could be everybody's reading those tea leaves. Police are closing the gates. This person said this. Maxine Waters is going to jail. It's like, what's going on?
My friend Eledian says he's getting good luck from PBS NewsHour. So,
well, we're good now because we don't have the spinning wheel of death
for the moment.
You see, now we've been here for almost an hour now, and we've got nothing. Come on. I wonder what they're talking about.
Oh yeah, well they're waiting for the all clear from everything. They're waiting for everyone to show up, and they're waiting for the all clear from whoever is organizing this in terms of the safety side of the National Guard or whoever. It's like, are we prepped and ready to go in case this thing goes south?
Viva!
Is Viva here? Hey, Viva.
Tell me if my mic is too loud.
You sound great to me.
You're good.
Okay. Yeah. So I'm behind. I've been in a car for the last like 2.5 hours.
Hold on, let me read the super chat. How can we expect the police to do their jobs moving forward? Was justified to use more force than the prosecution's witnesses. Was clearly with the clear history of ODing. Listen, it's not up to us. It's up to the jury, right? And I'll catch you up. Let me just do this last one. Ketchup on eggs? Yes or no? Yes. I'm a sick man, but yes.
Ketchup can go on anything, really, except for ice cream.
Well, I don't know about the ice. I might even put it on ice cream. And how do you think this will affect police recruitment, retention? Cops will resign over a guilty charge. I don't believe cops will resign over a guilty charge because you had all of them testifying against the guy. So, I don't think you get that. But now, Viva, what's up, bro? What's going on?
How you guys doing? Hold on, I gotta bring my screen back. So I don't know what you've said. I listened to 5 minutes about 40 minutes ago. But I suspect both of you think that short deliberation conviction is on the horizon.
That's usual.
Yeah, our thing was generally that's what that means, but OJ, because OJ was a short deliberation. So it can, but sometimes it doesn't. You know what I mean?
This was my theory. You're gonna hear the dogs barking like crazy.
Take back Justin Bieber, man.
It's funny, you guys get a lot of our good stuff and a lot of our bad stuff. Like you got Steven Crowder, but you also got Justin Bieber. Jim Carrey was good at the beginning, and then he went a little crazy because politics ruins everything. Here's my thought, and I made my prediction, in Twitter. But the charges here were sufficiently complicated that if you were going to get to like around the house conviction on all three, I would have thought the deliberation would take more time to get to a full conviction on all three charges. But we'll see. It's very, very short and very surprising. But you think is it going to be 5 o'clock on the nose, or is there going to be like?
They said 4:30. So
they said 4:30. So
yeah. So I think they just set everything up. My understanding is that they wanted to do this with plenty of daylight left, regardless.
How does the song "It's 5 o'clock somewhere" now play into this?
The True Legal Dream Team on the stream. Boom.
Represent.
Guys, I'm going to be back in 30 seconds because I want to show you something very funny. Hold on.
All right. Here somebody says ketchup on ice cream actually does work. Syrup is better, but things you learn as a child. Well, I haven't been doing ketchup on, but it is what it is. It is what it is. But hey guys, I'm going to say it's interesting because with this verdict, I just don't know I don't know what to expect because I honestly think it can go either way. Let me put Viva up so we can see what he's wearing because I can't see anything.
Oh no, here I'm wearing it right now. I have discovered nonviolent protest, lawful nonviolent protest. If everybody out there wears these in areas where you're required to wear masks outside, how are they going to know who to ticket?
That's true. It does look like your face is a little ashy though. So
well, yeah. I'm just, my prediction, by the way, it's only a matter of time before, by regulation, they make face masks intended to look like faces illegal. Guaranteed, because politics ruins everything, and the government pretty much ruins everything. And this is a local.
That's an awesome.
It's a local shop. Here, check this out. Custies. And I'm gonna put a little video up on Twitter because it's I saw this guy. He has a channel called Burnt Rubba, RUBBA, and he's been putting out these videos, been going like super viral. And I said, this is perfect creative nonviolent resistance. Everyone wears those outside. It makes giving tickets for non-face masks a little bit more difficult.
That's amazing. Now that's amazing. I actually like that a lot. I really didn't. I noticed you had something on, but I really couldn't tell if it was a mask or not. Wow.
And if I put my sunglasses on, it looks even better. Like if I back away from the camera and I put the glasses over the line, I mean, there's a guy in the States who has an entire channel dedicated to this, and it looks hilarious and gets reactions. I don't want to embarrass people who react badly for not wearing a mask, but I'm going to go to the protest to document the protest wearing this, and I suspect the police are going to say something.
That'd be awesome. You gotta film it the right way because they'll look first and they'll be, hold on, is that guy wearing the mask?
I've got 3 GoPros, so I can get I can get the POV. I can get this. What are the dogs doing up there? Okay. Yeah, this was a surprising text that someone, Eric Hunley, erichunley.com. He texted me and said they're announcing the verdict. I'm like, holy cows, that's fast.
Wait, were you? Well, I'll ask because I asked Uncivil. Or were you surprised at how fast they came back?
Yeah, I'm surprised. I mean, I have no direct experience with criminal jury trials and much less with jury convictions. I know Robert and everybody says typically a quick deliberation means a conviction. But there's a part of me that thinks that, and I can't know or not know or disagree with that. I just think a quick deliberation when it's a complex question of law might not be the sign of a conviction, because it would be a lot easier to dismiss the charges on short deliberation as opposed to make everyone appreciate, you have to discuss 3 convictions, 3 different charges, all 3 different elements for the 3 charges. That takes this was less than 24 hours. This was 24-hour deliberation. So it's interesting, and given the timing of what's been going on politically, politicians getting involved. Anyways, I don't know what to make of it. I just know I've made my prediction based on my own observations. Maybe right, maybe wrong, and it's nothing more than that.
We make predictions, like it's opinions. Opinions can't be wrong, right? It's what we look at the evidence, we look at the law, and we say, well, this is what we think. I'm going into this clearly saying I could be wrong. He could be not guilty on all charges. I'd be surprised, but it is what it is. You know what I'm saying?
I just say, like, for this, when one of the presentations yesterday, and Robert and I talked about it, Nelson, as far as I'm concerned, and it's not because I want to see or read anything, Nelson did breaking down the excessive force question, reasonable force question for an officer, where I know people are still going to disagree with it, because I still might disagree with it, but he did present a coherent argument for why it was not excessive force in the first place, which then becomes the easiest way to quickly dismiss all 3 charges on their face.
Yes, definitely.
Well, anyways, it's also terrible that a legitimate concern, if not the actual concern, is rioting in the event the conviction doesn't go the way people who are intent on rioting want it to go. This is not how judicial systems can function for any long period of time. It's not how they can function at all. And the fact that this is like the actual primary concern coming out of the judgment and not justice itself is it's not a good sign.
Yeah. I just the couple of things here that I disliked about what's happening now is the political pressure, right? I think well, for a case like this, you got to sequester the jury, because it's just ridiculous. Like, Maxine Waters and all that stuff. I think you kill all that if you have that. And I think the second piece of here is, I think the prosecutors, it just was too cumulative. It's you got 20 lawyers, you got this. It almost becomes like almost an equal protection issue. Like, would you do this for any, is this really equal protection? Would you do this to any other criminal defendant? Would you have this many lawyers and put this many resources? Even though they use resources like it was, at a point, it's like, this is starting to become unfair, but, justice has a course.
Well, but unfair and politicized, where, typically it's the state prosecuting, and Derek Chauvin's attorney is a public defender.
No. He's paid by the police union.
He's paid by paid by the police union, so
Yeah.
which is itself sort of a public entity. So you have the,
Oh yeah,
the
they have the
government.
money. They have the money.
You have the government prosecuting and dedicating massive resources. It looks like it comes off as a political prosecution to some extent, whereas in the ordinary run of things, it should just be the same resources dedicated on both sides and not look like it's of special importance to the government to bring in private counsel, and not just one, but multiple, to treat this like the trial of this. I mean, it's the trial of the century, but all for, I'll not say the wrong reasons, but it's...
Well, contrast this to OJ. Remember, OJ was the exact opposite. Two prosecutors and like 12 defense attorneys. But now you got the OJ in reverse. Two versus 12. So it is what it is.
If you go back to the chat, this chat, regardless of the verdict, how does the U.S. get out of this madness that has gripped the country given the weak I say this as a Canadian because I was just talking about it with my dad. Like, to see this sort of social cohesion disintegration in real time over the last however many years, and people blame it on Trump. People say that Trump was the cause of, or people are going to say Trump was the result of. One thing, it's just a question of how you see it. They occurred at the same time. How do you need leadership that is going to actually promote harmony and not divisiveness? And it's not coming from either side, really. Whether or not it's coming more from one side than the other, the bad divisiveness, I think it is, but people will call that political bias. But you just need people to tell everyone to tone it down and to come together and not burn the system down if you don't get the results you want, quite literally.
Yeah, this is for us. Viva and Nate perfectly get perfect on stream with it because they balance each other out. Uncivil, think we'll see anything go down in Austin. If not guilty.
I wouldn't put it past
what's it called?
I wouldn't put past it. I wouldn't put past it for New York City, for that matter.
Oh no, it's going to go crazy here. You know what I'm saying? If it's not guilty, we're going to have problems. But a good thing I have a lot of my stuff still, so I'd be scared to death. Great stream. Thanks for educating us all. Thank you for being here. Thank you for being here and checking us out. It's at this point, people keep saying that if it's a guilty verdict, riots. If it's a not guilty verdict, riots. I think if you have a guilty verdict, I don't see riots. I see people celebrating in the streets and all that stuff, but I don't see riots. I think you do have, but I think if it's guilty on, let's say, the man 2 and not guilty on the other ones, I think then you have a mixed bag. And it's a shame because it's different. I was watching, I don't know, well, I don't want to spoil it for you guys, but if you guys watch the Winter Soldier, which is called Falcon and Winter Soldier, I've been watching that show, and there is a different experience based on race if you're here in America. And it's different because of where you live. It's different because of who you interact with. And it's different because of where you grow up, right? We all have different experiences. And I think that is something that this country has to still get over, because you got the problem. I think we still have the problem where you have a part of our country who still believes this is 1965, right? Jim Crow law. And it's not that. And then you got the other part of the country who thinks we live in a race utopia, where everybody's seen equal. And it's not that, you know what I'm saying? It's somewhere in the middle. And I think until both sides kind of realize this is not a race utopia, and this is not, 1955, Jim Crow South, then we can start having a conversation about how to get these inequities out. But until we stop talking at each other and start trying to make the solutions together, then we'll always be here. And I think that's the biggest issue that we have now. And I think that's why this issue is coming to the forefront, because, they're starting.
Please be seated.
Here we go.
You got Larry David in the stream. Awesome.
He's looking at it now. I'm going to turn my light on.
The pressure that this judge has been under and is still under and will be under after this it's unfathomable.
Here we go.
All rise for the jury.
Are you guys heart pumping out your chest?
Well, yep.
I feel intellectually and emotionally invested in a way that's
Please be seated.
interesting.
Members of the jury, I understand you have a verdict.
Did we find out who the jury foreperson was?
Not yet.
No,
Okay.
we may hear them speak.
Members of the jury, I will now read the verdicts as they will appear in the permanent records of the 4th Judicial District. State of Minnesota, County of Hennepin, District Court, 4th Judicial District. State of Minnesota Plaintiff versus Derek Michael Chauvin, Defendant. Verdict, count 1. Court file number 27, CR 20-12646. We, the jury, in the above entitled matter as to count 1, unintentional second-degree murder while committing a felony, find the defendant guilty. This verdict agreed to this 20th day of April, 2021 at 1:44 p.m.
Just like I predicted.
Signed, juror foreperson, juror number 19.
Boom. Guilty.
No, then the other two are going to go as well.
Caption, verdict count 2. We, the jury, in the above entitled matter as to count 2, third-degree murder, perpetrating an eminently dangerous act, find the defendant guilty. Verdict
Woo.
agreed to this 20th day of April, 2021 at 1:45 p.m.
Guilty
Signed by
twice.
foreperson, juror number 19.
Guilty.
Same caption, verdict count 3. We, the jury, in the above entitled matter as to count 3, second-degree manslaughter, culpable negligence, creating an unreasonable risk, find the defendant guilty.
Damn.
Agreed to this 20th day of April.
3 for
2021
3.
At 1:45 p.m. Jury foreperson 019. Members of the jury, I'm now going to ask you individually if these
Gonna
are
poll them.
true and correct verdicts.
Poll the jury.
Please
This is
respond
it.
yes or no. Juror number 2, are these your true and
Damn.
correct verdicts?
Yes.
Juror number 9, are these your true and correct verdicts?
Yes.
They're polling the jury.
Juror number 19,
You ask each
are
one of
these
them.
your true and correct verdicts?
Yes.
Juror number 27, are these your true and correct verdicts?
Yes.
Juror number 44, are these your true and correct verdicts?
Yes.
Juror number 52, are these your true and correct verdicts?
Yes.
Juror number 55, are these your true and correct verdicts?
Yes.
Juror number 79, are these your true and correct verdicts?
Yes.
Juror number 85, are these your true and correct verdicts?
Yes.
Juror number 89, are these your true and correct verdicts?
Yes.
Juror number 91, are these your true and correct verdicts?
Yes.
Juror number 92, are these your true and correct verdicts?
Yes.
Are these your verdicts, so say you one, so say you all?
Yes.
Members of the jury, I find that
Damn.
the verdicts as read reflect the will of the jury and will be filed accordingly. I have to thank you on behalf of the people of the state of Minnesota for not only jury service, but heavy-duty jury service. What I'm going to ask you to do now is to follow the deputy back into your usual room, and I will join you in a few minutes to answer questions and to advise you further. So all rise for the jury.
They don't. Essentially, I'll make the defendant. Oh, yeah, they make him stand up. Damn. 3 for 3.
All right, be seated.
It's going to be
Hopefully she got
interesting
Verdicts returned.
to see
We're
what the
gonna
impact is
have,
going to be on police.
Blakely, you may file a written argument as to Blakely factors within 1 week. The court
What's a
will
Blakely
issue
factor,
findings
Nate?
on the Blakely factors.
It's for inherent.
factual findings.
If you want to
1 week after
enhance
that.
the penalty.
We'll order a PSI immediately returnable in 4 weeks. And we will also have a briefing on, after you get the PSI, 6 weeks from now, and then 8 weeks from now, we will have sentencing. We'll get you the exact dates in a scheduling order. Is there a motion on behalf of the state?
Move to have the court revoke the defendant's bail and remand him into custody.
Yeah, that's a natural thing. Yeah.
Bail is revoked, bond is discharged, and the defendant is remanded to the custody of the Hennepin County
Yeah,
Sheriff.
that's it.
Anything
So
further?
he goes to jail right now,
right.
regardless of what
Yeah.
happens.
Thank you.
Yeah. 3 for 3. Yeah, he's got to go to jail now.
Has it ever happened that when they poll the jury, they get something that defies
Yes.
what the written signal is?
Yes. If one of the jurors, then that's the reason why they do it. Sometimes one of the jurors will say no,
We're adjourned.
and then they have to go back.
And then what would happen then hypothetically? They go.
You go back. You go back.
and do it again.
Yeah, you go back and figure it out.
That was pretty quick.
Well,
That was
That was very quick. Not sure
Damn.
what I was expecting, but still.
oh my god. So we were right on the second degree. We were, but the third degree, as they were interpreting it, I kind of think that's what you got. But it just
No,
The third, if you got the second degree, then the other two are just kind of ancillary claims, right?
Is it possible to like get a feed from outside the courtroom? Because I'd be interested to see, as the verdict was read, how the reaction of the crowd is. Is that possible?
Sure, I'll do that right now.
Thank you, Nate.
But how do you guys feel about the verdict though?
The problem is that politics the politicians ruin everything. They might have come to this very same verdict, and in the absence of Maxine Waters saying what she said yesterday, you don't give fuel to the people who are going to say they were intimidated into this verdict. They were probably intimidated into it, not intimidated into it. They were probably intimidated regardless. It's not a trial that anyone would want to be a jury member on. But when you have politicians saying these things, it compromised, or at least gave the appearance of impropriety to what might have otherwise been the outcome regardless, and certainly gives the grounds for an appeal. But no, anyways, it was the easier decision to make and the easier prediction to make because, first of all, given the law in Minnesota, the felony murder law, I mean, whether or not that turns out to be constitutional or not, it was the easier prediction to make. But there was too much external factors here to taint what would have otherwise might have been the outcome regardless.
Yeah, I want to make it very clear. The reason why I was predicting murder to conviction, it's just because they had to prove an assault. And I understand how people don't, if you didn't want this verdict, you're going to say it's not felony, it's not murder. But think about it, people. For this conviction for murder two, they only had to prove he assaulted the man. That's such a low bar. It's ridiculously low. It's a bad law. It should be overturned. I don't know if it's constitutional or not, as Viva was saying, but that's as simple as it really got. And when you have something like this, this was my prediction was more about the felony murder rule and how obscene it was than versus really the facts that were presented. Because I think the facts support it, but the felony murder rule is just ridiculous, and we all know that.
I mean, and there will be a challenge to that. There will be an appeal. There'll be a challenge to the interpretation of felony murder, which Barnes, brings up legitimate points where they make certain distinctions for the underlying crime, excluding certain crimes. Doesn't make sense how the underlying felony to a felony murder could be the assault itself. Whatever, that'll be a question of law. Mm-hmm. Then you got all the external factors of politicians making statements that they know are going to reach the jury because the jury's not sequestered. You got the jury not being sequestered. You got certain statements being made during the trial. There's going to be an appeal, and who knows what happens on appeal, but it's just all of these external factors that taint what might have otherwise been the outcome regardless.
Yeah, I mean, I certainly agree as to the perception. There's, justice must be done and also be seen as being done. There must be a perception and a reality. And so we can split the difference and question both the perception and reality. I think a judgment the other way would also be perceived by other people in the political spectrum as being inherently unjust. As to me personally, I tend to be a little bit more process oriented than results oriented. So I tend to look for the purity of process rather than the outcome. And for me, there were minor issues, and I think they are minor because it's pretty hard to have a perfect case. It's pretty hard for every decision to be correct. It's pretty hard for everything to be perfect down the line. So were there minor issues? Sure, but there's literally minor errors in all the cases ever. Were these errors really fundamentally different? In my view, no. I think the process was fair. I think the vetting process for the jury was as thorough a voir dire as you could ever hope for. They went through it meticulously. I think the prosecution's case, although a bit cumulative, was compelling. Their witnesses were compelling. I thought the defense's case was underwhelming. Their witnesses were not as believable, not as compelling. And I thought as a pure legal issue, because Minnesota, but as a pure legal issue, yes, I found guilt on murder in the second degree as well. I was convinced beyond a reasonable doubt because of this, and this is an interesting issue because Ben Shapiro and I differ on this as a matter of law and how we interpret what a substantial contributing factor means. So what does that mean legally? Ben Shapiro seems to think it means a dominant factor or the principal factor, and I don't think that's legally right. I think it's much better as it needs to be significant, but it doesn't need to. So it's a difference between trivial and significant. And what Chauvin did is a significant contributing factor. It's not merely trivial or incidental. It's meaningful. And I think it's hard to conclude, in my personal opinion, that even if the drugs were a factor, even if his natural health was a factor, even if his heart disease, even if his high blood pressures, even if all these things were also contributing factors, even significant contributing factors, I think it's hard to conclude, based on the evidence as presented, that Floyd was not also killed, murdered by Chauvin in terms of the positional asphyxia, in light of all the warnings he was getting from his fellow cops in the crowd and all the rest of it. So I was convinced beyond a reasonable doubt murder in the second degree. I have some fairly technical reasons why I don't think murder in the third degree works. But I think this is a just verdict, and I think it was a just process. So that's what I think about it.
Yeah, I tend to agree. I think this was slow mode is now on, so 30 seconds. The slow in the chat. I think this was a just verdict. I think it was just based on the law and based on what we know about the law. In New York, it may have been something different. I also think that, again, there are no perfect cases. I think when it comes down to it, it really came down for me just the ease of the felony murder rule. I just can't overstate that enough. Proving an assault is it's just proving an assault is so much easier than proving manslaughter. No prosecutor or no one who knows anything about American criminal justice is going to say, and that's essentially what they had to prove here. And all the evidence and everything they had to prove an assault. Think about this, if this was a regular assault case with a regular person, would we even really be talking about whether this is an assault or not? And that's what I'm saying. So I think it was cumulative. I think there's some appealable issues, but I think at the end of the day, under Minnesota law, this is the right just verdict. Go ahead, Viva. I'm sorry.
No, I was going to say the felony murder law in Minnesota is the only thing that can really explain this easily. And some people were saying, well, what happens if you pull somebody over and they have a heart attack because they're scared about being pulled over? Some people were using that false analogy, but it has to require an underlying assault. The issue here is the reasonable doubt that I could see. First of all, the judgment is reasonable given the evidence, no question. I think an acquittal could have been reasonable as well.
Yes,
but the issue here is that it's not an ordinary person. It's a policeman who, by all accounts, was enacting what was to some degree policy. And now the issue became, was it policy after Chauvin, after George Floyd was non-responsive? That's where I've had the issues from day one. And I think the defense did a good job painting the picture of why Chauvin remained on him for the 4 minutes after he was unresponsive. But it's not an ordinary person. It's a policeman who was, to some extent, enforcing policy that he was trained to do, which the bigger risk now is whether or not it's a fair outcome, whether or not the process was fair, and whether or not the process gave the illusion of being untainted by external pressures. I'm not convinced it was. I don't think it was. And what effect is it going to have on policing? Because it is a very. I'm not anti-police, and there's no but. They have a tough job, and they need to do certain things. If they feel that they're walking on eggshells, is this going to have a much more negative, lasting effect? Or should the policies be revised in all of these police stations? But I've said what I said from the very beginning. It looked terrible. 4 minutes on someone who's non-responsive. You have to have there has to be some compelling reason. Whether or not the mob was sufficiently of a threat, defense did as good as the job they could. It could have gone either way, and both outcomes would have been equally justifiable. There's nothing fundamentally unjust about the verdict. It's just all of the external stuff that is going to give people the impression that it was the result of pressure and not justice.
This is saying, do they convict on all three? In the case, the greater charge is overturned. No, if they convict on all three, and that's it. And in other words, they're saying he committed every one of those particular crimes. So
because they all flow from the same act, unless Minnesota law says differently for some reason, then it would be cumulative rather than consecutive. So you would sentence them for every charge separately, but then all the charges get combined. So if the top count, say, is 20 years and then 10 years and 5 years, the ultimate result of that is 20 years. So they wouldn't be served in sequence because they all flow from the same event. But you get sentenced on all of them individually, and then basically the top one is the one that controls.
And up to 40 years. What does this mean for the other three officers? That means they're in trouble, because again, they only have to prove an assault And if they proved it here, then I think you might have the assault down there too, because again, theirs is more of an accomplice to the assault.
Yeah, and that, the mental state is different, and I think it makes a very substantial difference. Unless unless something comes to light that will change my mind, I think not guilty across the board for the other three.
I agree with that. I agree with that. Well, explain the difference between the mental state, because now I know a lot of people are going to be like, "Oh my God, Nate's this," Kurt this, but I agree with Kurt. I think for the other three officers, I think they lose based on the mental state. But explain the difference, Kurt. Sorry.
All right, so you have to look at everyone's mental state individually, which I suppose makes inherent sense. So what you believe Chauvin's mental state was does not, of course, read onto anyone else. So you have to consider that separately. So for Chauvin, the question was, did he intend to commit an assault? Obviously, yes. And because if anyone else did what he did, it would be a felony assault, right? If I did it, it would be a felony assault. So his only defense became justification. He can't argue it wasn't a felony assault. It doesn't even make sense to argue that. He has to argue justification instead. All right, so let's turn about the other three officers. Their perspective is differently. For them to be an accessory, they have to intend to help someone who they know is committing a crime. And so that's different. Like, so it would be the difference between me helping you as a bank robber versus me holding the door open because I just think you're another customer. You know, it goes to what my knowledge is and what my ability to perceive is. Let's suppose that the bank robbers call a taxi, and let's say that there's a silent alarm, and let's say that the bank robbers come out of the bank just strolling like normal customers, and the taxi takes them away. Is the taxi driver guilty of anything? Of course he isn't, because he has no knowledge from the hypothetical I just gave you to become a getaway driver, right? He doesn't know anything's going on. He's just been called by dispatch. He doesn't have any knowledge that transforms him into an accessory because he doesn't know anything. So the question is, what did the other officers know? And based on large part on their own, like, you should turn him over, you should move him aside, all their warnings and so forth, I don't think that you can get to them intending to help someone in furtherance of a crime. So I don't think that you can get to their intent to become accessories. I don't think their intent works. That's where I think legally it differs.
Yeah. Well, what if Chauvin had shocked him, which the police said as well is within procedures? But generally, I don't know their procedures, but you can't tase someone in handcuffs because people get tased to death. So you can't generally with their handcuffs, you can't tase them. And he died of a heart attack. So if you tase somebody who died in a heart attack, it all depends on whether you were justified to tase the person or not. So before he was in handcuffs, if he was doing it, if they were justified to tase him or not. So yes, if they tase him and they were not justified, he had a heart attack, that would be felony murder. But
the taser is actually a pretty decent example, because if it's a taser where you have to make contact rather than the prongs coming out, so if it's a contact taser, it might be justified use of force to, touch them for some period of time and become unjustified for some longer period of time. So I don't know what the training on this is. Nate would probably have a better idea. But it's like, if it's 2 seconds or 3 seconds, that might be one thing. If it's 3 minutes, that's a whole nother thing. So because the use of a taser would be justified to some length doesn't imply to all lengths. And for me, whatever the boundary of this justification was, it far exceeded it. So it's not one of those, and this is also why I don't think legally it really should be overly read by police officers as informing what they do on a day-to-day basis, because I don't think this is borderline on justification. I don't think this is like a difference of 10 seconds or 20 seconds that we're trying to splice this really thin. After there was no pulse, I believe he was still on his back for another 3 minutes, and it's like, how is that not, whatever boundary there is, that's crossed. So if you want to argue the boundary exists prior to that moment in time, so if you want to argue it exists even earlier than that, I'm not going to fight you necessarily, but I'm going to say it definitely existed at this point, clearly, and after that point, it doesn't make any sense. So I don't think this is nebulous on that ground.
Viva, you made the point about the constitutionality, and John is asking about the constitutional argument. If the Minnesota, because he says if they argue constitution of the Minnesota felony murder, but I don't know what would be the argument? Yeah. What would be the constitutional challenge to that? If the police powers of the state, what would it violate?
Challenging I guess the constitutional challenge that I would imagine is that this imposes, that it's an incoherent interpretation of the law. Basically, it's not how the law was intended to be interpreted. So they're interpreting it that way, but it couldn't logically be the interpretation, since it basically erases the meaning to any manslaughter resulting in death, because manslaughter basically, which results in death, because now you no longer have any manslaughter, you'll always have felony murder, basically. And so you're giving an interpretation to a law which basically nullifies or invalidates other existing laws, which then should be deemed to be an absurd and untenable interpretation of the law. That's not that it's unconstitutional, that the interpretation being given to it is unreasonable.
Well, see, and that's the issue with our constitutional system, is because this is a state law under the police powers of the state, and if the Supreme Court of Minnesota says this law is legal within their jurisdiction, then I don't really see your federal issue. Well, no, unless it's void for vagueness or something.
Well, that's the thing, because we're saying the law is legal, but it's how the law is to be interpreted. They're interpreting it right now to include that the underlying felony itself, which leads to the death, becomes the felony murder, which then, if you on that reading, it invalidates other laws, which therefore means that it has to be the wrong reading. So that's the law itself is valid, yeah, but we're talking about how to interpret that law and apply it to a specific case, where the logical reading of that law, even as drafted, should be that the underlying felony has to be separate and distinct from the act that actually led to the death. Otherwise, you've basically invalidated or rendered moot existing laws, which can therefore not be a valid interpretation.
What you've just explained was called the independent felony rule, and I agree. But it's interesting because and again, this is just my understanding, is that a state law read by the state, Supreme Court, they're the ultimate arbiters of what that state law means, how it's interpreted, and how it's applied. And if they are interpreting and applying it this way, I do think there's a problem. I think it's insane, but I just don't see maybe the federal issue that brings it up. Maybe Kurt, you said something, but I do, and I agree with everything you've said, Grieva. I'm not saying I disagree. I'm just trying to understand the federal issue that could, because right now, and I hate to even say this, I don't see that anyone would have standing to bring this in a federal court, right? What do you think, Kurt?
Yeah, as to the state Supreme Court, because I couldn't believe this was the rule in the first place, I did a look up on Westlaw for Supreme Court of Minnesota cases dealing with this issue about whether or not you could use a felony assault as a predicate felony for felony murder. And I found several cases that were directly on point that said, yes, you can. So this is a question that Minnesota Supreme Court has directly tackled on point multiple times. At least 4 or 5 times, and every time they've said it, even in recent vintage. I'm trying to remember when the last time they did it, when it was last century, or 20th century was last time. But they've said if the legislature wants to change this, they can. Yes. But this is a rule of law that we have in Minnesota, and we're not going to change it. So I can't imagine the Minnesota Supreme Court is going to reverse that based on anything. The precedent seems clear. And they've considered the question directly, and they said this is a question for the legislature. If they want a different result, they can. And so I don't see that happening. The murder on the third degree is a little bit interesting because there's that bomb. And I could try to find the exact case if you guys want to cover it. But there was a case dealing with whether or not third degree murder could apply if it was specifically targeted against a particular individual.
That was the case that was up on appeal during this case, right?
No, there's an older case that's a little bit closer on point.
Okay.
There's an older case that's closer on point, and I felt like in lieu of that case, that third degree murder doesn't work technically. So we'll see how that gets interpreted down the line. And
that's probably have to go up, because I would definitely appeal that too. Riva, go ahead.
Yeah, reading Wesley's comment here, if Ashley Babbitt got justice, I would be more okay with this. This is the issues. Everyone has to appreciate the conviction was based on the underlying act being deemed to be excessive force. That's then once you get to that conclusion, you get to all 3 charges. That was deemed to be excessive force, what Chauvin did, and having watched the video, that was my initial impression, although I saw the defense raise good arguments. Yeah. Then you get into a situation, different state, different law. I don't know what qualifies as excessive force in DC, but I would imagine point blank shooting someone with one shot. If that's not excessive force, and this is, you're dealing with situations that people cannot reconcile, and it's going to cause a great deal of distrust in the system. I'm not jumping to the racial distinctions or the political distinctions. Just talking about two different circumstances where, in one case, kneeling on someone's back while they're restrained for 9 minutes is excessive force, and another person effectively executing someone at point blank range, whatever the fear was of that agent who shot, is not excessive force. People are going to stop having faith in the system, and then they're going to look for ways to explain away their loss of faith, and that's a big problem.
Well, I think, well, personally, I think in the Ashley Babbitt situation, it's not comparable in one sense. In one sense, you have people, again, because it's all about context, right? Here, you have a handcuffed suspect, 9 minutes. That's one scenario. There, you have people who are barricaded in, VIPs in the back, and cops with guns pointed at the door telling people, stop, don't come in, don't do it. People, even the witnesses there said, yeah, we heard the police say, stop, we're not joking, don't do it. They break down the door, right? Break through the door, break through the barricade, and then someone jumps up to get through. At that point, do you let her come through? Do you know what she has? So if I'm saying this, I would have shot Jacob Blake, right? Because I think Jacob Blake was a risk with him with the knife going in, grabbing into the hand, and I would have shot him. I would have shot Ashley Babbitt, right? I would have done that because I don't know what she has. She's in the middle of a riot. She's coming through, and it's not like she doesn't have fair warning. Stop, don't do it. When I tell you to stop, and she chose not to stop, right? She's the one. Now, Ashley Babbitt to me seems more closely to suicide by cop. If this was just someone jumping through a window and getting shot, that's one thing. But I think the context of the matter, there was, they're screaming, kill a vice president. And we're protecting the exit for the vice president. So, I think nuance is key, I think, with Ashley Babbitt. But I do understand what people mean because
you're talking about the escalation of force based on the threat. And I understand the argument. It's not that I don't understand the argument. And yes, she's in Ashley Babbitt's case, you're in a government building where there are politicians and it's going to be treated differently. But the question is going to be escalation of force. Why not a taser versus a single shot point blank range into the neck? I mean, the question is going to be escalation of force, and in what circumstances are charges even brought versus convictions? And people are going to have trouble reconciling. There is an argument to be made, but people are going to have trouble reconciling.
Well, I have to respectfully disagree with my friend Viva here on this issue. I don't think it's anything close to an execution in this scenario with Ashley Babbitt. I don't see it. The scenario is so different than anything that's comparable. This isn't similar to the police officer that shot the person in the back as they were running away in South Carolina. This isn't similar to other instances of police abuse. In this situation, you had a large number of people who were shouting things that reflected an intent to harm others, to kidnap others, to commit serious crimes. There's a large number of them, a large force of them. They were barricaded. The police were trying to warn them using other force. And I think that the shot in this situation was a reasonable use of force. I just don't agree with that posture. And, it's...
Two things, not to get semantic on you, Kurt, but it is an execution by definition, which is a putting to death, especially as a legal penalty. So it was a putting to death because that's what it was, as a legal penalty, but as a response.
I would have to disagree, because if you say that, then every shooting by every cop would legally be an execution, and I don't think that makes sense.
No. I was saying, first of all, it's semantically, but when you are killing someone as a threat, I mean, there are different terms to the execution. It is hyperbolic in a sense, but it's also just another meaning of the term, not the legal sense of an execution, which is you have a conviction and you're carrying out a judgment. This was carrying out a judgment just on an instantaneous scale. And I do agree with what they were doing, with what Ashley Babbitt and everyone was doing. You're definitely pushing the envelope as to getting that response. But that doesn't necessarily mean that. What does the police force say for gradient for escalation of force? Why not a taser? And I'm not saying why not? I don't know what the warnings were. I've seen the video. chaos.
Police,
But-
don't get down. Don't shoot.
Well,
We'll shoot.
not necessarily, because even the cops behind, there's an argument to be made that nobody heard that because there were cops right behind Ashley who didn't hear it either. So there's arguments, but it's a situation where you are storming a building that has politicians in it. You increase the likelihood of something like that happening. The only question is, point blank, taser could have been another reasonable escalation given the threat. It's not like
those cops. But that's assuming those cops had tasers too, because the one that shot Ashley bad was a plainclothes guy. So that's assuming he even had a taser.
The question isn't are there other reasonable steps the police could take? Because of course there are. The question is whether or not the step they took was a reasonable step, not whether there were other
that depends. Whether or not it's a reasonable step depends on whether or not there were more reasonable non-lethal methods that they could have used to attain the exact same objective. So that is what other. First of all, plainclothes officer is another problem in that case, not a good thing. And whatever. Obviously, they're not analogous. The only question is they're going to be perceived as creating two unequal systems, and people are going to look to explain those away politically and racially. And it is the problem when rules are not applied equally, is people look for explanations and they're going to find them.
The police's role is in this situation, when we're talking about the Capitol riots, is not only defense of self but defense of others. They're trying to defend themselves against a potentially lethal threat, and they are right to perceive it as a potentially lethal threat because of the numbers and because of what they had already done that day and because of the things they're shouting. Just from raw numbers, they can perceive the threat to themselves and threat to others. So I think that police acts in a self-defense posture, both to themselves and of others in this situation. So again, I have to strongly object to the idea that self-defense qualifies as an execution, whether it's me doing the self-defense or a police officer.
Self-defense has got to be proportionate to the threat.
Yeah, it does have to be proportionate, and for the reasons I say, I think it is proportionate in this situation. I mean, let's just put let's put yourself in this posture.
I understand the argument.
If it's you in this posture, and you have this crowd outside the door, and they're beating down the gates, as it were, both literally and figuratively, and now they're starting to jump through the windows. Would you, as a reasonable person, be able to perceive that as an imminent threat of death or grievous bodily harm? I think you're there.
The castle doctrine. That's essentially what we're talking about. We're talking about
go Nate. If you can bring up Rowan Cloud's comment, if you can see it, it's above the Mike 2017 super chat, two above it, where he says, "Viva, storming implies that there weren't people that were waved in by police." We're talking about two different things here. The people who were waved in by police, I'm not saying they stormed the Capitol there, but the incident where Ashley Babbitt was, they broke a window and were trying to jump through the broken window. So that I would call that storming. I would call that trying to gain access to a room that was closed. And then the only question is going to be, is a point blank shot the justified response to that perceived threat? And that's where you're going to have people disagreeing. But no, I'm not saying they stormed the Capitol. I saw some of the stuff. They were let in. Others broke stuff down. But at that particular incident, there was a door that was blocked, a window that was broken, and she was trying to jump through the window. I mean, I call that storming, but then we're just...
I'm a huge believer in the Second Amendment. I'm a huge believer of the right of self-defense. I believe it's a moral right to defend oneself against an imminent threat. And I'm just trying to put myself in that posture and looking at the situation, given what I know at the time. All right, what do I know at the time? I know that people have been storming the Capitol. I know there's a horde outside this door that are trying to literally beat down the doors. I know they're trying to break down the windows. I know that they're shouting things that obviously put in mind threats of death and grievous bodily harm, not only of me myself as this cop, but also of the others that are in my charge that I'm trying to protect. Now suddenly I have one of them, presumably to be followed by others, or in that moment, what can I reasonably observe in that moment? I've got this person jumping through the window, even after I've warned them repeatedly. To my mind, and this comes from a position of belief in the Second Amendment, comes from a position of belief in the right of self-defense. It's like I'm putting myself in that posture. Would I reasonably be able to perceive that as a threat of grievous bodily harm? Yes. Could I use other methods? Yes, I could. The question is, am I justified in using lethal force? To me, the answer is clearly yes. And I don't think it's double standards to hold so. I don't think it's an execution to believe in the right of self-defense. And I don't think the right of self-defense changes inherently just because you're a police officer. So, I mean, we don't have to belabor the point because we've been talking about it back and forth for a while, but I just have to really strongly but politely disagree with my friend, who I do consider my friend even though we disagree.
I never met in person yet. The only one I met is Nate in person right before the world fell apart.
Right before the wars.
My worthy colleague.
Does this apply in Portland? No, Portland's in Oregon. We're talking about Minnesota. So yeah, threatening federal buildings. And again, actually, this felony murder rule doesn't apply for defensive property crimes. So if it's a felony defensive property, it doesn't apply. Could Chauvin have claimed to being aroused by the assault?
I think you want to stop reading that comment.
Yeah,
this is when you bring up the chat before reading. Some chats are intended for humor and not necessarily public reading.
All right, cool. I was going to read it, Mike. Shooting randomly into a crowd is unreasonable. There's reasonable. No, it's not. But shooting toward a threat that's coming through a door, possibly. But again, these things, these things are fluid. Go ahead, Viva.
No, I was gonna say that they're fluid. It's a split second, but it gets very reminiscent to like the cops shooting one protester to send a signal to the rest, which is, I don't know what the rules are on using live fire in a protest. And I think they did an investigation. They came to their conclusions. My questions would be, what were the alternatives? What are the rules about using live fire on protesters? Because that's what they were. They were breaking into a room, yes. And, whether or not that was a reasonable escalation from a plainclothes officer who had issued a warning, which, may or may not have been heard, given the fact that he could have just as easily hit someone behind her, who could have just easily been an officer.
Well, just to be clear, the standard so all we know is, what would a reasonable officer do in the same set of circumstances when presented with the same threat that this officer did? So what they'll do is say, what a reasonable officer facing that same set of circumstances, would they in that same situation, would they had fired, would they had done that? And if it's a yes, then it's justified. If it's a no, then he's not justified. The Women's March during the Kavanaugh hearing won. So people are, this is against for Kavanaugh, persons were VIPs in the elevator. Yeah, but it's the Kavanaugh thing is a lot different than, it's a lot different than the
posture is so different. I mean, the question is almost slightly absurd. To be quite honest, I mean, it's absurd because it's a completely different factual picture.
Yeah,
when you're looking at the immediate situation, the immediate surroundings, there might have been more people involved in the Women's March in total. Were those people all banging down the door of the elevator? I mean, it's a completely different factual posture.
This one actually, and just we can totally different set of facts. But Anthony brings up the good philosophical question, and it's a tactic that some lawyers have used, in arguments is, if both possibilities are, justifiable, necessarily there's a reasonable doubt. So how can verdicts of innocent and guilty both be reasonable and the jury not achieve reasonable doubt? What I mean to say by that is, I can see how the jury reasonably came to the conclusion that there was no reasonable doubt. And I could see how someone who not wanted to, but rather who was inclined to believe there was reasonable doubt could have found it. But it's like the bottom line, especially given the provisions of the law, which we all know, like master Minnesota lawyers now, felony murder is almost easier to prove in Minnesota than manslaughter. So
it is. No, that's not that. That is a true. What you just said was a true statement. But I have two problems with these issues. The verdict cannot be innocent because it's not guilty or not guilty. We're only judging guilt versus not guilt. So that can be reasonable. And reasonable doubt is on the question of guilt, not innocence. We don't prove people innocent. We just prove people guilty. So that's the philosophical problem with this question. It's the reasonable belief on guilt, not innocence.
Let me comment on this question. Let me comment on this question as well. When I say both things are reasonable, what I mean is that when you as a juror are interpreting things, the weight of evidence is a question for each juror, and also the believability of the witness testifying. So when I'm asking questions like this, say, would both not guilty and guilty be reasonable? I'm trying to ask the question, would a reasonable individual be able to perceive the witnesses and the evidence and weigh them in such a manner as a reasonable person could do to come out with both decisions? And I'm like, yes, that's why. So that's why I can simultaneously say, for me, this is proof beyond a reasonable doubt. And also say, but I can see, because I'm answering for myself on terms of how I weight the witnesses and how I weight the evidence. So when I say, for me, it's guilt beyond a reasonable doubt, I'm like, this is how I weigh it. But I'm trying to put myself in an objective standpoint. I'm trying to say, could a person weigh the evidence differently or look at the witnesses differently so that they could come out with a not guilty conclusion? Yes, I could see that happening even though I'm not doing it. So that's why I say both are tenable conclusions, but I also say that guilty is the correct verdict from my standpoint, if that makes any sense.
Yeah.
Yeah, it does. Uncivil. You're talking about State v. Lowe, blah, 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 Minnesota.
1896, that looks right.
Yeah, I only did a cursory search. Minnesota. Yeah, that's when the third degree. I've seen a lot of those third degree felony murder cases. He's correct. They went way off the rails with third degree. But again, you know, where you do your crime is where you do your time, right? So it's just that.
Well,
let me
gentlemen,
just hold on. I'm just taking care of two more, and then I'm.
Yeah, go for it. Sorry.
I got to cook dinner. 2,300 people, only 850 likes. Come on,
Yeah,
people,
that's what I want to see what you were at now for the likes. So let me go ahead and see if that. Did I like this yet?
No.
Sacrilege.
No.
I didn't do it. You're
That's
at
okay.
550
Once you
now.
go off, I could go live because I already got it
Thank
running.
you.
Haha.
All right, yeah. You already got it running. So listen, guys. I got dinner to cook for children and for a wife because I'm a house mom now. Thank you guys for watching. Thank you guys for joining me, Viva and Uncivil Law. But I'll say this: two things. Number one, I think this is important to say. This case, I think, was less about the verdict was less about race and more about police policies. I think race got mixed into it because people saw it in the history of this country. But he wasn't charged with, murdering the guy because he was black. He wasn't charged. He was charged for violating police procedures. And I think people have to understand that too. To say race doesn't play a part in American culture would be naive. But to say race plays a part in all of these cases, I think also is naive. And I think in here, if people are still saying that this Floyd was killed because he was black, I think that's wrong. I think this was just an excessive use of force, and that's what the jury came back with, right? So understand. I think if you understand it from that perspective, then we're talking law. If you understand it from another perspective, where this is some racial animus, you're understanding from a political side. That's why I don't believe that even the newer case, the one with the taser, the mistake in a taser, I think that's an overcharge, right? Because it doesn't, even though race race is apparent, but I don't think it played a role in this case. I don't know if you guys agree with me or not, but I don't think race was a factor in this case.
I think the situations get racially politicized strictly for political reasons. And in the Ahmaud Arbery case, I think race might have played a factor.
Yes,
in
race, yes.
George Floyd, I don't think it did. In Kim Potter, I don't think it did either. It's just that when it's there, the media is going to play it up. Politicians are going to play it up because it's an easy way to garner, get your base excited. And it's an easy way just to drive some political relevance from a tragedy. And it's become a terrible reflex that's become more divisive than unifying at all by only trying to find race in everything. But yeah, no, this is a question of police force from beginning to end, police policy, and so some people saying he got his day in court. Everyone is now going to be able to say that there were other influences that affected this other than justice itself, and that's what happens when the process gets tainted.
With that said, Uncivil Law, you get the last word because we're about to go out.
No, I mean, I've enjoyed the discussion as always. I enjoyed talking to Viva Frye. It's been a while, and I'm glad that we were able to have a conversation again. I hope we can do some more stuff in the near future. I think that this makes a lot of sense in terms of the facts, in terms of the law. Well, the law itself might not make sense, but that's a whole nother set of issues. But I think I think this was a just verdict. Whatever pressures might have been on the jury, I'm as I try to be as detached and reasonable as I can be, and this is the conclusions I've come to, for better or worse. So justice was done as far as I'm concerned. And
just so everybody knows, the streak continues. We're at third. Somebody actually been counting 13-0, baby. 13-0.
Well, you're only 2/3 right. So do you get credit for that?
That's true. That's true. Well, I said the top count, but that's true. But they said.
And I'm going to plug the video that I'm going to drop in right after we end.
Definitely.
Project Veritas suing Twitter for defamation. Yes. I walk through the lawsuit in the next video.
Good times.
Boom. Go check it out, guys. My name is Nate the Lawyer, and I'm going to check you next time for Uncivil Law for free. Peace. All right, we're out. Listen, guys, I got to go make some mac and cheese.
Do it.
All right, guys. So now it's just going to be me because the stream is over with Nate. So now you just have me, your boy on Civil Law. How exciting. So I was very pleased to have the stream with my friends here. So I will answer the many, many questions you have been asking me along the way, because obviously I've been trying to talk to my friends here. But I'll ask the questions you've been asking in my bot from time to time. Grace Case asked, I haven't read any of the medical reports, so that may be in there, but could we not argue he had an acute exacerbation of hypertension due to the crap going on? Sure. Yes, you could argue that. The question would be, what is the source of that acute hypertension? So yeah, if he died because his hypertension was exacerbated, why was it exacerbated? And if you say, well, it's the drugs, yeah, maybe. Was it also Chauvin? Yeah. Excited delirium, Matthew says, well, that could be a thing too. It could be excited delirium and Chauvin is still guilty because of a substantial contributing factor, right? There can be multiple contributing factors. Zafael said, I believe there are restrictions on experts in Minnesota. Probably. But the prosecution had 3 bajillion. So I'd be a little bit surprised if the defense wasn't able to do that as well. Does it make any difference if they knew each other? It might, in terms of informing the intent, but it didn't come up at trial, so I guess not. Who decides the sentence? The judge does. And the judge will also determine any aggravating factors that may apply. It's a theoretical max of 40. It's a little bit unlikely he'll get that much time, but the judge decides the verdict. Could you argue kidnapping is eminently dangerous? Sure. I think for sure. With respect to third degree, isn't the proper interpretation of other still an open question? Well, Kobe, we're going to get to the case that I wanted to find yesterday that Matt finally found, State versus Lowe. So we'll discuss that in this stream, and then I'll also cut it up separately and release it as a short. Well, it won't be that short, actually, by the time we're done. But we'll discuss the applicability of third degree murder under the State versus Lowe case of 1896, and we'll see if he can be charged or not. Potato Cat says, could you elaborate further on second degree versus third? I did that yesterday. At what point will they have to use a taser if there's resistance, as they dare not go hands-on? Or are we at the police point? No, not legally. I think this was well over the line, in my opinion. Look at the Knorr case. That's not the one I wanted. State versus Lowe is the one I wanted. Thoughts on Maxine Waters? We covered that yesterday. Eva asked, if he's convicted on mobile charges, does the judge get to decide if they're served consecutively or concurrently? Yes. They should be served concurrently. They should be served concurrently because they all flow from the same act. They're not independent acts, so I can't think of any reason they would serve consecutively. So whatever the top line number is should be the number that will be applied. Dogbert says, I think your detractors have problems telling apart legal issues from policy issues. Quite possibly, but I try to make that distinction clear for anyone who is listening, right? I try to make clear, here is the law, here's my view of the policy, and try to make those distinctions clear, but yeah. Dogbert says, thoughts on the House being some sort of MMP-like parliamentary system. No particular thoughts on that. Not getting enough buffering from PBS. Uncivil law. Frank asked, are you having some drinky doos? Just some Guinness, which has been very pleasant. Uncovering hypocrisy says, do you remember how long the jury deliberated in Casey Anthony? Not off the top of my head. Frank Barron said, the troublesome trio are back at it again. Yeah, it's nice. It's nice to talk to my friend Viva. It's been a little butt stuff, and it's nice to have that here. Where was I? Unsurprising verdict. What will be surprising is the wide-scale riots that don't happen? Yeah, probably. Tia says, will this change anything? Probably. It will definitely change policing a little bit. And I think probably for the better, all things can be considered. You know, I'm concerned about police abuse. I think, you know, the right to one's bodily integrity is a conservative value. The Fourth Amendment is an amendment, right? We have a right to security in our persons. You know, the Fourth Amendment reflects a right of security in our persons. So I think it's fairly conservative, in my opinion, to say, well, one of the things I want to conserve is the Fourth Amendment. The Fourth Amendment talks about unreasonable searches and seizures. This would qualify as an unreasonable seizure within the meaning of the Fourth Amendment. The police are performing a seizure of the person. This is an unreasonable seizure. It's a Fourth Amendment violation, which incidentally means that you could sue under 42 U.S.C. 1983, but it doesn't matter because they've already settled. Potato Cat says, not sure it's responsible for you to let Viva mistake facts of the case. Knee was on the neck, not back. It was not disputed. What is disputed is lethal. It was a little bit of both. Depending on exactly where the knee was. But I don't think it really matters that much. Too much, because the issue would be, well, it matters a little bit. So the issue would be like, was there so much pressure on the neck to cause him to the neck way to collapse? There doesn't seem to be evidence to support that. Was there enough pressure on his body to cause positional asphyxia because his lungs and his rib cage are being pressed into the concrete? So even if it wasn't on his neck, is the pressure on his back enough to kill him? Probably yes. TS says, will it be away from other jailmates? That's up to the Bureau of Prisons in the respective state. Rowan Cloud says, the statement just made, although there is a verdict, this is not the end. Well, there is sentencing, and I don't know what they mean by that. Anne Elizabeth says, Nate is going to get some racist hate. I hope not. Daniela says, you're absolutely right about Minnesota law being broken. Yeah, I mean, it is what it is. It's not that I'm a fan of it. It is just what it is. Megan Gilbert says, I'm more nervous about the outcome in the U.S. after sentencing. We saw what happened after LaQuinn McDonald. And Danielle says, it's strange to me that he can be convicted of all those charges at the same time, but that's just me. Yeah, well, that's it. That is what it is. Because in Minnesota, a third degree is not a lesser included of second. The way it's written, they're not lesser included charges. They're independent because reasons. So, that's all good stuff. So those were all the super chats that you gave, or all the regular chats you gave me. Let me see if I can go through the super chats that you've been giving me. Barney gave me 25 Croatian krona. Some love well earned, but damn. Certain right-leaning elements in Nate live chat sure do hate you. Tough night for being a mod. I mean, I figure it's interesting too, because Nate is more left-wing than me as a general proposition. I'm more right-wing than Nate. So it's interesting that the right wing from Nate's chat hates me. But, so be it. It's my opinion for better or worse. So, and also I try to be as consistent as possible without going to my team. I think because I try to be principled as much as is possible for one man to do. So I don't look at this from a perspective of what is my team, or I try not to, as much as one person can factor out that bias. I try to look at it from a consistent philosophical vantage point, which I was discussing with Viva in relation to the officer that shot Ashley Babbitt at the Capitol, right? So it's not like, okay, I don't want to come to the conclusion because maybe right-wing people were doing the thing, or maybe it was left-wing officers. Like, I don't want to do that game. I just want to analyze it objectively as much as one man can. So I'm like, okay, what is the law in this situation? All right, so we can look at it from a self-defense standpoint. It's like, okay, so let's say it's me in this standpoint. How would I perceive reality? And I'm like, given what I know at the time, okay, here's what I think I know at the time. Here's how I perceive reality. Here's the conclusion that follows. So I just try to apply it consistently, logically. I think one of the things that conservatives tend to be a little bit better about, although this could be a bias issue, so maybe it is, but I think conservatives tend to be a little bit better about being consistent in terms of logic, because they tend to look things at more rule-based orientation, in my view. So I tend to look things in more of a rule-based hierarchy. It's like, what is the rule? All right, here's the rule. Self-defense. Okay, how does that apply? Blah, blah, blah. Let's move on. Fourth Amendment is a value. It's a value in the Constitution. It's one of the things I want to conserve. I'm an originalist. I'm a textualist. Okay, let's look at the Fourth Amendment. What does it say? We don't have unreasonable searches against a person, unreasonable seizures against a person. Okay, what does it mean to be seized? Well, it means that you're under control. Was Floyd under control? Of course he was. Was it unreasonable? Yes. So therefore, it's a Fourth Amendment violation, right? So I try not to do this by teams. I just try to do it by a fair interpretation of the law, even if I disagree with the law, as I do in the Minnesota case, because I don't really like the felony murder version in Minnesota. I think it's broken, as I have explained many, many times. The fact that I think it's broken has nothing to do with my conclusions as to its constitutionality, however. It has nothing to do with my applying the facts to this set of law, however. It's just looking at the situation and trying, as best as possible, to be as consistent as possible in applying my principles all the way through, no matter who it is, right? Without passion or prejudice, just apply my principles as best I can. Now, does that mean that I'm always consistent? Of course not. I'm a human being. I falter like everyone else, but I try. I try to be as consistent as one man knows how to be. So, good times. So that's basically what I have to say about all that. So let us look at this case that Matt found for me, because this is the case that I think is from 1896 that I found before, that he was kind enough to actually find for me this time. So thank you, Matt. And we're going to read this case, and we're going to see whether this case precludes Derek Chauvin from being convicted of third-degree murder as a matter of law. So let's try to analyze that. Now, I have to do this on the fly, so you'll forgive me as my screen gets a little bit weird because I have to do the orientation as I'm streaming in real time, so it's going to look a little weird for a second, but we'll make it work. You guys understand. You guys love me, or you hate me, or you hate watching me. Either way is fine, I guess. Let's see. I need to download this. Oh, is it only three? It's only a 3-page decision? Oh. Is this? Yeah, it's only a 3-page decision from the Supreme Court of Minnesota. I didn't realize it was that short. Okay, that makes it really easy. I mean, for us, we're used to reading decisions that are much, much longer, as you guys well know. So I'm going to do a little intro here because I'm going to cut it out separately. So I'm going to do my intro and we'll cut it out and release it separately. So you guys will bear with me here, all right? You guys get to see the behind the scenes in real time as we make it work. like it's batch record. It's a batch record, but you guys, yeah. Well, it's a batch of one in today's stream. All right. Let me do this. Yeah. State versus Lowe. Good times, right? Ooh, exciting. All right, let me put on my A game here for a little bit of a batch record moment. And this is going to be one take. Fun. Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. If you're enjoying this legal education content, please remember to subscribe. It helps the channel grow. For today's story, we are doing a discussion of third-degree murder in relation to the Derek Chauvin conviction and the George Floyd murder. This is the case of State versus Lowe from 1896. In this case, the Supreme Court of Minnesota is analyzing the third-degree murder statute, and it speaks to the issues at hand with respect to the Chauvin-Floyd incident. So we're going to read this case, and we're going to try to determine amongst ourselves whether or not we think, given this precedent, whether third-degree murder is tenable or not. Let's get started with this. What just happened? I put up the wrong window. Okay, I have to redo it. I'm sorry. I put up the wrong window. My bad. I have to redo the intro. I told you we're doing it live. There we go. That's what I want. Let's try that again. See, this is how you know it's doing live, because we screw up things like using the wrong window. It was a good intro, though. So I might keep the intro. No, I can't, because it overcut with what I was doing, so I have to redo the intro. Oh, well. That's all right. We try again. We learn, but we learn through my misfortunes, too. We learn through all the misfortunes. It's exciting. All right, let's try that again. Good times. Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. If you're enjoying this legal education content, please remember to subscribe. It helps the channel grow. For today's story, we are dealing with third-degree murder in Minnesota in light of the recent Derek Chauvin conviction. This is the case of State versus Lowe from the State Supreme Court of Minnesota in 1896. In this case, the Supreme Court of the state of Minnesota is looking at the third-degree murder statute and trying to determine its applicability. And I think that this case has direct legal relevance to the Chauvin case. So the question is, in light of this case, can Derek Chauvin's conviction on third-degree murder stand legally? So we know what the jury thought, but the question is, as a matter of law, is it legally tenable? Well, let's find out. Let's get started with this. if I can make this any bigger. I need to make this bigger. This is so small. I wonder if I can zoom on this or something. Zoom. Not without screwing up the margins. Let's see. Let's try. Nah, I'll just make it work. It'll just be small. I'll make it work. No, I hate it. I can't make it work. No, I'm having problems today. Okay, we'll make it work. Charles Lowe is accused by the grand jury of the county of Ramsey, by this indictment, of the crime of murder in the third degree, committed as follows. That Charles Lowe, on the 5th day of July of 1895, in the city of St. Paul, in that county, then and there, did wrongfully, unlawfully, feloniously, and without authority of law, with the design then and there had entertained by him, that Charles Lowe, to the effect of death of one Clara Berg, but without deliberation and premeditation, killed and murdered Carla Lowe. To wit, Carla became sick in labor of childbirth, was induced to go with and taken by Charles to a room in a building known as the Globe Hotel in St. Paul, upon the express promise and agreement of Charles Lowe to her that Clara Berg, that he, Charles Lowe, for hire and reward, be given and be paid to him by her, would be, during her sickness in and during the labor of childbirth, provide to her by her treatment, care, and medicine of a skilled physician, the nursing care and attention necessary to give her in her sickness, together with all other things she needed during that time of duty. Okay, wow. So first of all, this language is a little bit antiquated. So we're going to have to translate this from English to English. All right, so let's do that. Let's translate from English to English. Okay, so what we got is Charles Lowe over here. Okay, we got two people on our story. We got Charles Lowe, this guy, and we got Clara over here, Clara Berg, the pregnant woman. All right, so we've got Clara Berg, the pregnant woman, who apparently at this moment in time is about to go into labor or is in the process of labor. And Charles over here says, what about if you pay me and I will take care of you in your childbirth? This is, I suppose he's a midwife for very immediate hire is what we're going with. Midwife for very immediate hire. How about you pay me money and I'll be your midwife? All right. So she apparently says, okay. And he takes her to a hotel and he says, in exchange for this money that you're going to pay me, I'm going to take care of you. I'm going to give you the things that you need in this time. Now, right away, we know without anything more that this is assumption of duty, right? It doesn't strictly matter at this point whether or not Charles is in any way qualified for this role because he's adopted it voluntarily. Now, whether or not he's qualified or not will speak to his ability to perform the duty, but he has undertaken the duty. He is, by contract, whether it's oral or otherwise, he has a contract, in fact, to deliver this service. It's not even a contract for goods. It's a contract for services. So it's like in exchange for money, I'll provide you the services of midwife. I will take care of you and make sure that you have the medicine and care that you need and all the good stuff. So he has assumed duty. Now, when you have assumed a duty, you have to follow that duty through. And if you do not follow that duty through, that can be many things. It can be civil negligence, and in some cases, it can be criminal. If you do not, normally you don't have an obligation to others. But if you assume that the obligation to others, then you do have that obligation, and lack of performance can be a thing, right? So Charles over here is going to take care of the pregnant woman. Let's see how well that goes, I guess. All right, let's read some more. Okay. So then, Charles Lowe, from this 18th day of June until her death, evincing a depraved mind, regardless of human life, and in an act imminently dangerous to others, unlawfully, feloniously, and by design, although with a premeditated design to effect the death of any individual, failed, neglected, and refused to procure her any medicine for care, treatment, or attention of any physician or medicine man, and refused to allow her to be nursed or in any manner be treated for or cared by other persons, except for one instance which he permitted one W.H. Sigler to visit and prescribe her, said Clara Berg, but no other times, during which, at this time, from the 18th day of June until death, she, Clara Berg, was by said Lowe kept in this room in the sole charge and custody of Lowe, from which anyone want to break up a period? Do they not believe in run-on sentences in 1896? Lord have mercy. Anyone want to bring up punctuation at any point? She, from which said room she was unable to go, and from which she refused allow others to come, and during all said time she was sick and in great suffering and pain, and in consequence of labor, from blood poisoning and all other diseases and sicknesses to the grand jury unknown, and was unable to move or procure or ask anything from assistance of any person, which said blood poisoning, disease, and sicknesses were then and there threatening and imminently dangerous to the life of Clara Berg, and she was then and there during all these times in great and immediate need of treatment, attention, and medicine of a physician, and the care and services of a nurse, all of which Charles Lowe then and there well knew, semicolon, not period, but semicolon. Okay, we're going to treat it like a period anyway. We're going to treat it like a period anyway because that's a lot of stuff. First of all, we've learned something. Apparently in 1896, even at the level of Supreme Court Justice of the state, we don't believe in the concept of run-on sentences or that not being a problem. We're all totally fine with the run-on sentences. Run-on sentences are great. We love the run-on sentences. They're the greatest thing ever. We love them so very, very much because we don't believe in like periods. We just believe in commas. Lots and lots of commas. All the commas. We're all about that comma life. That's what's going on in 1896 in the Supreme Court of Minnesota. That's what we've learned first and foremost. Lord have mercy. Okay, we're going to translate that from English to English, probably involving periods, because that might be a good thing. All right, so what did we learn? Okay, we learned that Charles over here basically neglected his duty, and worse than that, he intended to neglect his duty. So what are Charles's motivations over here? We don't really know, nor does it legally matter, but Charles over here said, how about I be a midwife for you? And then he kept this woman locked up in the hotel room and didn't care for her and refused to allow her to care for herself and refused to allow people to care for her. And except for this one instance from this one guy, W.H. Sigler, who at one point visited and prescribed something. But other than that one instance, Charles Lowe over here, the defendant, didn't do anything to help Clara. Zero things. He didn't care for her. He didn't get her things he needed. He didn't provide her medical care of any description. He didn't hire others to provide medical care of any description. He kidnapped her, basically. For what motivation, I don't know. But he did. And he's a very, very bad guy. So what the Supreme Court of Minnesota here also notes is that he was, in addition to evincing this depraved mind of I don't care, he also actively intended this result. So he not only had a depraved mind, he had worse than that. He had an intent, according to the Supreme Court of Minnesota, which we'll just take as given that it was found at trial because, Supreme Court of Minnesota. But apparently Charles over here, for reasons, had the active design and intent to cause this death. That was his goal. He was trying to achieve that, apparently successfully. What his motivation is, I can't say. But what I can say is that he kept this woman in a hotel room, refused to allow her any kind of treatment, refused to give her any kind of treatment, neglected her needs in every possible domain until she died of blood poisoning. So, super great guy. Super great guy. So it's going super great over here, and the Minnesota Supreme Court has to consider whether or not Charles is guilty of third-degree murder or maybe something else. Okay, let's read some more. Punctuation, man. Punctuation. Woof. I mean, seriously. Seriously. Anyone want to talk about punctuation at any point? Lord have mercy. Okay, let's continue on. Okay, we stopped at a semicolon. We'll continue at the semicolon. It was at said times the duty of Charles Lowe to procure for her treatment and medicine of a physician and care services of a nurse, and he was at all times well able to procure and furnish all the same, according to the terms of his promise and agreement, in accordance with his duty, semicolon, still not a period to be seen, by reasons of the failure and neglect of Charles Lowe, here before mentioned that she, Clara Berg, did languish and languishing, did live until the 5th day of July, so that's a long time. He kept her basically prisoner from the 18th day of June until the 5th of July. That's a long death, man. Just saying. So this guy has a really, really cruel streak, man. She died very slowly. Wow. Yeah. On which last day she died in the county and sickness therein. All right, super great. So what we've learned in this portion, where we finally hit a period, thank God, is that Charles Lowe had the ability to do these things. He had the means to do these things. He had agreed to do these things. He had the duty to do these things because he undertook the duty. And then he said, how about no? How about I want to kill this woman? How about I let her die very slowly in this hotel room when she can't be cared by anybody over a period of, what is that? Yeah, 18th day till the 5th day of July. Yeah, so, like 3 weeks, basically. So how about I want this result to occur? I want her to die. Charles isn't a great guy over here. That's what we've definitely learned. But yeah, he had the ability to do it. He had the duty to do it. He didn't do it. He didn't do it because he wanted this result. Okay, great. Let's read some more. We are of the opinion that the facts that have been set out in the indictment would not, even if properly set out, constitute murder in the 3rd degree. All right. So he was convicted, apparently, of 3rd-degree murder, right? And the Supreme Court of Minnesota has to figure out whether or not this is 3rd-degree murder under the relevant definition of 3rd-degree murder, right? So we're asking the legal question, is this 3rd-degree murder? He might be guilty of something else, but he wasn't convicted of something else. He's convicted of 3rd-degree murder. So the Supreme Court of Minnesota says, okay, there was a bunch of objections to how the indictment was laid out. But we don't think that was the issue, because we think, even if it would be set out correctly, you can't get to murder in the 3rd degree. You can't get there legally. So this wasn't merely a defect in the indictment. This was a defect in such a stuff. You can't insult my chat. You can't insult my mods on my chat. I'm going to redo it because I don't even know where I was. But I'm not going to allow you to insult my mods on my stream. That's not acceptable. All right, where was I? Okay, now I have to redo my entire thing because I don't know where I was. All right, so I have to go back to square one. Thanks a lot for making me lose all that shit. Just want to thank you from a personal level for insulting my mods through a super chat, so now I have to redo it. You're a jerk. Great. Okay, so the Supreme Court of Minnesota has to determine whether or not this is 3rd-degree murder under the relevant statute. And they're saying, no, it's not. Now, they're saying critically here that this isn't merely a defect in the indictment. They're not saying that the indictment was somehow flawed and, that was the issue. They're saying that even if the indictment had been written correctly, that they couldn't get to murder under the 3rd degree legally. So this isn't a problem because the defense complained that the charge shouldn't stick because the indictment had a flaw, which may or may not be cognizant as a legal issue, right? Maybe the indictment had a flaw, maybe it didn't. But maybe that's not really the problem at this point, even if it did. But the Supreme Court says, well, it's not that the indictment had a flaw. That's not the real problem. The problem is, even if the indictment had been perfect, it wouldn't be workable. This is not murder in the third degree. So now we have to figure out why, under Minnesota statute, it's not. Now, take note here, we're not saying that it's not bad. We're not saying that it's not manslaughter. We're not even saying it's murder in the second degree, which just sounds suspiciously like it might be. We're asking the much more specific question of, is this murder in the third degree? So let's figure out if it's murder in the third degree. Okay. The portion of the relevant law above quoted was intended to cover cases where the reckless, mischievous, or wanton acts of the accused were committed without special regard to their effect on any particular person or persons, but were committed with a reckless disregard of whether they injured one person or another. A very full discussion of the meaning of this portion of the section may be found in the opinions of other cases. But in one respect, we do not agree with the reasoning in that case. It is held there, in order to bring a case within this statutory provision, the reckless act of the accused must jeopardize the life and safety of more than one person. So this was also an issue in Chauvin. So there are two distinct issues here at play. So let's make sure that we get this straight. There are two distinct issues at play. Does the act have to threaten more than one person? Is the act targeted against more than one person? Those are two different issues, right? So you can have an act that threatens other people, even though it's targeted at one person. So an example would be if I'm specifically intending to shoot a particular person in a crowd, right? That would be an act that is targeting a specific person, but obviously it's a threat to everyone in the crowd, right? So I can target a person and also threaten other people. And I suppose the reverse is true. I guess the reverse would be true in murder 3. The reverse is technically true. I'm targeting the crowd. I'm not going after any particular person. So yeah, there's a difference there between the two things. So there's a question of what's the target and what's the threat, right? So the one example would be I'm targeting the individual, the crowd's at threat. The other would be I'm targeting the crowd, the individual is at threat, right? So who am I targeting and who's at threat? I'm targeting the individual, maybe I'm threatening a crowd. I'm targeting the crowd, I'm threatening an individual, right? So there's two distinct issues here. How many people do we have to target and how many people do we have to threaten? So the Supreme Court of Minnesota is about to talk about the how many people do we have to threaten part of this equation. All right, so let's do that. We do not determine it necessary that more than one person was or might be put at jeopardy by the act. The relevant law says the singular number includes the plural and the plural is singular. It is, however, necessary the act was committed without special design upon the person or persons with whom the murder of the accused is actually charged. The acts and omissions here in question are not of that character. They had special reference to Clara Berg. It was not the case where the act or omission did or could affect any person or persons who happened to come along or be in the way at the time of the act or omission. So yeah, that seems to be directly on point for Chauvin, right? So, okay, who was target? So we know when the statute says that it has to threaten others, we know that one will be fine. One is fine in terms of the threat. Or no, one is okay in terms of the threat, but not the target, right? So if the threat is against a particular person, as long as some others could also be threatened, even hypothetically, it might be enough, right? So the Supreme Court is like saying here, or they seem to be alluding to, they're not strictly saying, but they seem to be alluding when they say it could not. They seem to be alluding to the idea that maybe theoretically it could threaten someone else. So they're not saying that if it could theoretically threaten someone else, but it doesn't, maybe that's enough. But they're at least alluding to the possibility. So maybe you are threatening only one individual, but it could theoretically be the case in some other situation that other people could be threatened by that. So maybe the scenario might be, geez, how do we even dream up a scenario like this that would make sense in a legal world? Okay, you're recklessly shooting into a shop window that you can't see through, okay, because glare or something. Work with me. All right. So you can't see into the shop window. All right. So you are recklessly, with depraved mind, shooting into the shop window, and you happen to kill somebody. All right. Now, the question might be, does it actually matter how many people are actually in the store at that time? Right? In reality, does it matter? Right? Does multiple others have to actually be there, or is it enough that theoretically other people could be there? Because those are two distinct worlds, right? So maybe it's the case that only one person was in the store and you managed to hit them. How unfortunate for you. And maybe it's the case there are 100 people in the store and you managed to hit that one, right? We don't know. We don't know from the fact that you hit one how many people were in the store. Does it matter how many people were in the store or not? And the Supreme Court seems to be at least alluding to the possibility, although they're not outright saying, that if you could theoretically strike someone else, it might be enough. So they seem to be at least alluding to the possibility that if this act could strike someone else, it might be enough. So if it's during routine business hours and normally there's other people there, but for some reason not so much today, maybe it's enough, right? But this situation isn't that. Whatever the shop window example is, this is not this. We have a singular person in a hotel room, very, very isolated. And we are very much targeting this one individual. And there's not anyone who is even theoretically at risk from this other than this one person. How could there be? What other risk is there to anyone else in this reality? There is no risk to anyone else in this reality. So, and there's no possibility of risk in this reality. It's not the shopkeeper hypothetical example that I dreamed up on the fly. So the Supreme Court of Minnesota is saying, well, whatever might be true in shopkeeper window land with glare during the business day, whatever might be true in that reality, in this reality, no one else is threatened, right? So they're saying, okay, it doesn't matter that reality. It doesn't matter. But what does matter is that you were specifically targeting someone. So the Supreme Court of Minnesota says there is a difference. There is a difference between intending to shoot someone in particular in a crowd versus shooting at a crowd in general. Those are two different things. If you intend to shoot a particular person in the crowd, that's murder too, right? It's murder too. Even if you hit someone else, it's murder too, because intent follows the bullet, as we all know, right? Or you all should know. Intent follows the bullet. So if you're intending to shoot a particular person in the crowd and you hit that person, it's murder too. If you don't hit that person and you hit someone else in the crowd, it's still murder too, because intent follows the bullet. You specifically targeted a particular individual in mind. Now, whether or not you succeeded in killing that particular individual or not, if you kill a person, it's murder too, because intent follows the bullet, as we all know and love from our coverages, right? So if you're intending to kill someone in particular, that's murder too. Murder 3 is distinct. Murder 3 is I'm not trying to kill anyone in particular. I'm just evincing a depraved act to people in general. And maybe they're hypothetical people in general. So maybe it's murder 3. We don't know because the Supreme Court doesn't clarify. Maybe it's murder 3 if I shoot a gun just capriciously and I just happen to hit someone and they're the only person on the street. So new hypothetical. I am acting in reckless abandon. Maybe I'm trying to celebrate an event. I don't know. I'm celebrating New Year's. Or let's make it something that's not, I'm celebrating an event. Maybe it's my birthday. I don't know. And I decide the way I want to celebrate this event is by shooting guns in the air. Or not even in the air. Let's make it worse. I'm just going to shoot the air. I'm just going to shoot the gun at eye level in a random direction because I don't know. That's how I feel like celebrating my birthday today. And I'm doing this in the middle of the street in broad daylight. Okay? This is our hypothetical world. All right, great. So I'm not intending to kill anyone. I'm just going to shoot a gun at arm level in a random direction because that's how I like to celebrate my birthday. Great. Now I managed to kill somebody doing this. Wow, well, that was a shocker, right? Now, does it matter if this street has only one person on it or multiple people? We don't know. So maybe it will be the case that if I do this and I strike one person, and for reasons, this is the only person on the street that could even possibly be hit by this bullet because, I don't know, it doesn't matter. Maybe that's still murder 3, maybe not. Because I wasn't targeting that individual, was I now? So maybe the fact there's only one person who's even hypothetically at risk is not important because it could be the fact that someone else could be threatened. It just didn't happen to be at that moment. So what's true in reality might be true or different. So maybe it's still murder in the third degree if I shoot my gun in a random direction and I happen to strike someone, even if they're the only one, because I wasn't targeting that person. Right? That's murder 3. Maybe. Or maybe it matters if there are other people. But either way, it's not murder 3 if you're specifically targeting an individual. And in this case, our protagonist over here, or our defendant over here, was specifically targeting this person. So it can't be murder 3. So yeah, this case seems to be directly on point, in my legal opinion. I don't see how you can read this and get to the conclusion that Chauvin can be held guilty of murder 3, given this precedent. Yeah, let me see if there's any difference between the way the third degree murder statute reads today that would make a difference. Let's see if it's a difference of somehow the statute has changed. Hold on. All right, has the statute changed in a way that's going to actually matter as to this analysis? Let's find out. How exciting. All right. All right, here's how it used to read. I don't know if I can actually put it, well, can I put both on screen at the same time? That'd be really cool. Is there a way for me to do this without breaking everything? Is there a way for me to, I need a split screen or something. I need some sort of split screen ability. Damn. How do I do this? All right, hold on. We'll have to do it the hard way. Hold on. Bear with me. Hold on. Hold on. Hold on for one more day. Things will go your way. Hold on for one more day. Do. All right, let's see now. Okay, so that will work for half. And then I need to create a new window. So let me do that. New window capture. Window capture. I want to change it to this thing. Great. I want to capture that, not capture the cursor. Great. All right, let's do that. All right, now I need to shrink this down. There we go. See, it's coming together now. Oh, look at that. Oh, it's almost like we're a professional or something. All right, victory. No, I have to do that. Yep, no. All right. Yeah, the way I've done this. Okay, because I've done it stupidly. All right, that's fine. So I can't look at chat at the same time. That's fine. We'll just do it stupidly. All right, fine. All right, so now let's, well, no, I have to adjust this a little bit more because I've got not quite all the text on screen. Close, but not, let's just make it a little bit bigger. Yeah, there we go. All right. Okay, so now on screen we have the two different statutes. The one from 1896 is up top, and the one for the Floyd murders on bottom. So we get to compare and contrast two different statutes and see if there's a statutory difference that for some reason this precedent would not apply. All right, great. So we have what used to be section 6440 of the relevant law is murder in the third degree. And today it's section 609.195. All right, so let's read section 6440 from 1896. All right, such killing of a human being when perpetrated by an act eminently dangerous to others and evincing a depraved mind, regardless of human life, although without premeditated design, to the effective death of any individual is murder in the third degree. Okay. And then the one today. Whoever without intent to effect the death of any person. Well, can I? Yes, I can. I can actually I can highlight things along the way where it's the same language because we've got markup tools. How nice. So we can mark this up so we can see exactly what the language is that matches. How cool is that? Where's my highlighter tool? There it is. Great. All right, so we'll highlight language that's exactly the same from the old today and today. All right, so without intent to effect the death of any person is basically the same as this language, without a premeditated design to effect the death of any individual, right? So that's basically the same language as in the statute. Without intent to effect the death of any person, without a premeditated design to effect the death of any individual. That's legally the same, right? Premeditation is intent. It's more specific because we've changed the language slightly, but it's the same thing. Individual is person. So that language is the same in the statute legally. There's no difference there. Causes the death of another by perpetrating an act eminently dangerous to others and evincing a depraved mind. Okay. Perpetrating an act eminently dangerous to others and evincing a depraved mind. It's the same statute. Without regard to human life. Regardless of human life. Same language. Is guilty of murder in the third degree. Is murder in the third degree. So we've gone at language. Yeah. So we've gone by section by section. It's exactly the same language. I mean, it's slightly modified for modern English. So it's slightly modified for our modern penal code, the model penal code. So it's slightly modified in light of the modern language. But this is exactly substantively the same. So in light of this language, I don't see how Chauvin can be convicted of murder in the third degree because it's not legally tenable. If this case from 1896, which seems directly on point, I don't see how Chauvin can be convicted of murder in third degree. So I don't know what the Court of Appeals is going to do. But in my view, it doesn't work. So that's what I have to say about that. Are there any questions before I wrap this up? Because I'm going to still try to make an edit from this. Are there any questions? Because I haven't been paying as much attention to the questions. Let me see if there's any questions on point. Do other convictions stand if third degree murder is overturned? Yes. Every charge stands independently. So yes, every charge is independent. So if murder third is overturned, murder in second and the manslaughter would stick. Yeah. Yeah. Well, as the verdict, it was guilty across the board. Matthew, you're my resident legal student. What do you think? Do you think that there's any way? Do you think there's any way I'm wrong on this? I mean, this language seems right on point. So I'm open to suggestions. Give a second for the chat to come up because the lag is unbelievable today. Talk amongst yourselves. Yeah, it's dumb, but I'm right. Yeah, I think so. Does YouTube really take 65%? No, it's not that much. I think YouTube takes, I forget on the ad split version. I think they take 33%, 35%, something like that. They don't take 65%. No, not much. Planton's arm says, you know what you're saying right now is forever? I don't know if you're talking to me or not, but this is a legal interpretation. So, I mean, do I think conviction on third degree is a mistake or unclear instructions? Okay. I don't think the jury made a mistake. I think the judge made a mistake in allowing the charge to go to the jury. The jury is charged with applying the law as the judge explains it, right? So the judge explained it wrong. He made a legal error. So the judge didn't, the jury didn't make a factual mistake. The court made a legal mistake. And that's why it will be reversed on appeal. There's no, you cannot read State versus Lowe and come to the conclusion that this makes any sense. Yeah. So, no. All right, I'll wrap it up. Excuse me. So that brings us to our end of the discussion of State versus Lowe, an 1896 Supreme Court case from the state of Minnesota. In this case, we learned about murder in the third degree, and we looked at the Minnesota interpretation of this third-degree murder statute, which to my eye looks exactly the same as the third-degree murder statute of today. You know, it's slightly different wording for a more modern language, but it's exactly the same substantive. It's the same idea. So this case seems to be controlling. And in this case, the Minnesota Supreme Court considered two different things: who's being targeted and who's being at risk. And the Supreme Court said, maybe it matters how many people are at risk, maybe not. But if the act is specifically targeted to one specific individual, it can't be third-degree murder. That seems to be the clean conclusion of the case. If it's targeted, it cannot be third-degree murder. So therefore, it seems very difficult to argue, because the thing that killed Floyd was Chauvin's body weight, presumably, on him that was creating the positional asphyxia. So how could anyone else be at threat? It doesn't seem tenable. So I do not think the third-degree murder statute will survive appeal. I don't know if the Court of Appeals will reverse it or the Supreme Court of Minnesota will reverse it. I suppose they could overrule themselves from 1896. But short of them overruling themselves, this case seems directly on point precedential. So I do not believe that murder in the third degree can survive. Now, that being said, the murder in the second degree and the second-degree manslaughter will continue to survive. So it'll be a bit of a Pyrrhic victory, because one would imagine the second-degree murder is going to carry way more time, and one would imagine they're all going to be concurrent sentences. So as a practical matter, it probably won't matter in the end, but they're going to appeal on it, and they should win, as long as the Supreme Court's abiding by this precedent. Seems pretty clear to my mind. So, yeah, I don't think the third-degree murder statute is going to survive on appeal, and that brings us to the end of this discussion of this case. Fun. Yeah. All right, so now we can go back to discussions on the broader issues of the day. Now we've done our little excerpt story. Can you cash at me directly? Yeah, you can. Well, you can just pay me through PayPal. The link for Streamlabs is coming up from time to time, and they accept PayPal. So you can donate through PayPal if you like. Maybe I should put the payment icon on stream rather than using Instagram. I can do that. Hold on. Let's see if I do this, if this will work. Yeah, there you go. There you go. How about that? There you go. Because I made PayPal. All right, so let's discuss the Chauvin case and some other stuff. No, the sentence has not been determined yet. It's up to 40 years, but I don't think he'll get that much. I'd expect something greater than 20. So I expect something between 20 and 40. Are we likely to see removal of some charges as a matter of law because of murder? No. Supreme Court of Minnesota seems very clear on this too. It's like 5 cases on this point. There's like 5 cases on point, including some very recently. I mean, comparatively. The Supreme Court has made it very, very clear numerous times. So I don't think the murder thing is going to work now. It's probably really stupid, but I honestly don't understand how QR works. Do I screenshot and use this app to read it? Your camera app in your phone probably can read it automatically. So if you use a camera in your phone to look at it, the camera app should be able to pull it up automatically. Yeah. Any new smartphone should be able to hand it for you without any problem. Well, it's not weird that you can charge someone twice for the same thing because there can be different crimes in the same act. So the same crime can encompass multiple different acts and multiple different crimes. So that's not particularly unusual that you can charge multiple different things as long as they're distinct offenses. So they're distinct. They're legally distinct because, yeah, the one does not. In order for something to not be distinct, they both have. Okay. In order for two things to be the same charge for double jeopardy purposes, let me phrase it a different way. In order for two charges to not be the same, they each have to have at least one element that's not in the other, right? Okay. So normally, like third degree murder is normally a subset of second, is normally a subset of first, right? So in most places, like if you're guilty of first degree murder, you're guilty of second degree murder, you're guilty of third degree murder, right? Because usually most states write them like, it's third degree murder, and if you have this one more thing, it's second degree murder. If you have this more thing, it's first, right? So in that perspective, in that way, in most states, third degree murder and first degree murder are not legally distinct. Because if you have that where it's a lesser included, right, the first degree murder statute has an element the third degree doesn't, but not the other way around. They both have to have an element the other doesn't. So in order for two charges to be distinct, they both have to have at least one element the other doesn't. So in a normal statute where first degree murder includes second, includes third, right, the first degree murder statute has more stuff than the third, but the third degree murder statute doesn't have anything different. It lacks something, the first degree murder statute, but doesn't have a different element. It needs to have something different and it doesn't. So they're not legally distinct charges. Okay, that's a normal world. In Minnesota world, third degree murder is not a subset of second degree because of the way the statute's written. And manslaughter in the second is not a subset either because of the way the subsection is written. So they are legally distinct charges because they contain different elements. The mens rea of third degree is different. The actus reus of third degree is different. Well, I'll bring it right there. So, you're there. So, good times. Guidelines suggest 150 months. Thank you, Rakita. Nice to have you here, by the way. Thank you, Rakita from Rakita Law. Yeah, Rakita, by the way, I just did a whole story just now on State versus Lowe from 1896. And in my opinion, I'd love to hear your opinion on it because I just did this whole analysis of State versus Lowe from 1896 on third degree murder. And we just did it as a story, and we'll excerpt it later for an individual thing. But in my opinion, State versus Lowe precludes murder in the third degree for Chauvin. So if the Court of Appeals applies the precedent seems clear. It seems directly on point, clear. So short of reversing the precedent, which I'd like to take note the Court of Appeals can't do if they have any loyalty to the state Supreme Court. So the correct decision on appeal should be to reverse the third degree murder conviction. It is not legally tenable. The prosecution is wrong. The trial judge is wrong. There's just no way in my view, to read State versus Lowe and think that the third degree murder statute is tenable against Chauvin. It just does not work. So I expect the third degree to be reversed. It won't make that much difference in an end, but it's not legally tenable. So the trial judge is wrong. The prosecutor is wrong. That's what appellate courts are for. So we'll see how that goes. Thank you, Nick. Appreciate it. Enjoy your show, man. Enjoy your show. Love to talk to you sometime about this stuff, man. It's great stuff, right? I'm going to watch his show, actually, because I'm about done. So I'll probably head off myself and watch Nick's show when he starts because, he's awesome. And I'm about said what I need to say. Does it change anything with sentencing if overturned? No, it probably won't. It probably won't. I can't imagine that will. I mean, it will eviscerate the third-degree murder sentence, but since they're all being served consecutively, and I would imagine the second degree is going to carry more time, then I don't think it's going to make any difference. So, no, I don't see it happening. I don't see any obvious issues of appeal for the other statutes, of the other things. I don't see anything obvious. So, yeah, he is guilty as of this moment. Yeah, he is guilty. And that's the issue on appeal, right? Because I was explaining this earlier on the stream with Nate and Viva, right? You always interpret things in light of the current reality. So up until 2 hours ago, Chauvin was innocent. He's innocent till proven guilty, right? So what that means is all the evidence is interpreted in light most favorable to that reality. All the evidence is interpreted. That's what beyond a reasonable doubt means, right? So up until the point he's guilty, all the evidence is interpreted in light of the then current reality, which at that point was innocent. He was innocent. So all the evidence is interpreted in that reality. But now he's been convicted. Now he's guilty. So now everything flips on appeal, because now all the evidence will be interpreted in light of the current reality. The current reality is now he's guilty. That's happened now. So proof beyond a reasonable doubt has now happened. So on appeal, the question isn't proof beyond a reasonable doubt anymore, because that's already happened. The question is, did the judge make some sort of did something happen? Here's the ultimate question. Did something happen, or did a combination of things happen that if those things had not happened, okay, let me rephrase that slightly, because they have to be legally, they have to be like errors. So it's not just enough. Okay. Did something happen that was wrong? Did something happen that was wrong, or a collection of things happen that was wrong, that if that hadn't happened, a reasonable jury could not convict? Okay, let's make sure that we're all getting this, all right? So make a list of all the things that you think that happened that were wrong legally, right? Make a list of all the things that you think that were wrong legally, all right? Now assume those things hadn't happened, all right? Could the jury still come to the verdict of guilty? That's the standard now, because he's been convicted. So all the evidence is now interpreted in that light. So let's say, for example, just to make this easy, say, for example, that one of the prosecution witnesses shouldn't exist. I don't know, pick your poison. It doesn't matter for this hypothetical. Let's say one of the EMTs shouldn't have been allowed to testify. I don't know, doesn't matter. Pick your person, right? Let's say they shouldn't have been allowed to testify. Great. All right, so the Court of Appeals, so you go to the Court of Appeals and say, you know what? That EMT should not have been allowed to testify. Here's what the Court of Appeals is going to do, assuming you're right, okay? We're assuming you're right. Here's what the Court of Appeals says. They say, you know what? You're right. That EMT shouldn't have testified, so their testimony no longer exists. Now, here's the question. Is there enough testimony remaining that a reasonable jury could convict? Is it possible? Okay. You don't think that EMT should have testified? You don't think that question should have been posed? You don't think that doctor should have been allowed to testify, or he should have been allowed to say that? You don't think the prosecutor should have been allowed to say that? So forth and so on? Great. If all that hadn't happened, could a reasonable jury convict? Because now we're interpreting everything in light of the current reality, which is conviction. So in order to get this overturned, you have to find a thing or a series of things, which in their combination, if they hadn't happened, would mean a reasonable jury couldn't convict. So take the Maxine Water thing, for example. Take the Maxine Water example that even the judge noted, all right? So you say, aha, first of all, the jury doesn't know about it because they weren't sequestered at the time, so it doesn't matter. But let's even assume that they weren't sequestered at the time. So the jury doesn't know about the Maxine Water thing because they were sequestered at the time. And as a matter of law, we do presume that the juries are always in following instructions. That's a matter of law, right? The jury follows the instructions. The jury has been told to avoid the news. They were told not to watch the news. So we have to assume as a matter of law, they have not watched any news relevant to this case, because that's law, right? Now, whether or not you think that's true in reality, can we ask the jury about it? Of course we can. Of course we can, because jury deliberations are secret, don't you know? So we can't ask the jury We can't ask them anything. So we have to presume the jury followed the instructions. And one of those instructions was not to follow the news. So, of course, they don't know about Maxine Waters. So, but let's assume that they did. Even assuming they did, could they convict without that? Of course they could. There's enough evidence there. Maxine Waters' statements was not the linchpin of the prosecution's case. Could a jury convict? Of course they could. Of course they could. So the question for appeal is, can you find a thing or a series of things that, had they not happened, it would be unreasonable for a reasonable jury to still convict? So good luck on that is all I have to say on that. Good luck on that. I don't think the defense has anything for second-degree murder or second-degree manslaughter. I mean, they'll try. They're going to try. They're going to raise all kinds of issues. There's just none of them are going to work in the end. They're going to raise all kinds of issues. The witnesses were unduly cumulative. They were unduly prejudicial. That question shouldn't have been asked. The prosecutor's statements during closing were unduly belittling. Blah, 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 blah. And the Court of Appeals is going to look at it, and they're going to be like, well, let's assume the prosecutor hadn't made that statement. Let's assume this hadn't happened. Let's assume all that happened. Would it have changed things? And the answer is no, then they don't even have to ask the question further. So, yeah, I don't see anything or any combination of things that looks like an appealable issue, except for the third-degree murder statute, which we just covered, because it's not legally cognizable, because it was never legally cognizable in the first place. But other than that, is the second-degree murder statute legally cognizable? Yeah. Does murder exist in this context? No. Do I know that for sure? Yes. How do I know that for sure? Because the Supreme Court of Minnesota has said this multiple times. Many times. Several times. They've made it abundantly clear in their precedent that if this wants to change, the legislature can change it anytime. They're not going to do it. So can they say that second-degree murder is unconstitutional? Nope. Will they try? Yes. Will it succeed? Nope. The precedent is solid. It's even more solid than the case we just covered. That's how solid it is. On the merger thing, it's even more solid, because in the merger thing, I've got like 5 cases that tell me that. In this Lowe thing, I got 1 case. So can they say it's unconstitutional under state law? Nope. Can they say merger? Nope. Is there a legal error there? Nope. Is there a legal error on the manslaughter? Nope. Is there a factual error that's going to matter? Nope. Did the judge make a clearly reversible error that's going to manifest in a difference? Nope. Is there a manifest abuse of discretion? Nope. I don't see anything. The defense will try, but they're going to go down horribly, is my prediction. There's nothing there. So, no. Stefan says the jury had major reasons to convict based on their own well-being and not on the facts. Yes. Stefan, you are correct. You are correct. It doesn't matter, though. That's what I've been trying to tell you. The jury had reasons to convict other than guilt, other than the facts. The jury had reasons to convict other than the facts. Sure they did. The question is, could a reasonable jury convict merely on the facts? Not what did this jury do, because we don't pierce the veil of the jury. We don't ask those questions of the jury, because we know that this is a fair jury, because we did all the vetting and we gave them instructions accordingly. And they all said that they could be unbiased, and they gave it under oath, and, all that stuff. So, they're a fair jury. They're a fair jury, because of course they are. So we can't ask the jury. We cannot ask that question. So the question isn't, did the jury have reasons to convict other than the facts? The question on appeal would be, could a reasonable jury convict on the facts? And the answer is yes, in my opinion. In my opinion, the facts are they can convict on this series of facts. Do they have other reasons other than the facts to convict? Probably. Does it matter on appeal? Nope. The only thing that matters is, could a reasonable jury convict on the facts? Not did this jury do it, but could it be done? Because remember, we're beyond proof beyond a reasonable doubt. We're beyond presumption of innocence. That's over now. Presumption of innocence is over now. That is not a thing that exists now. Presumption of innocence is done now. We did that. It's over. So now we get to do, okay, can the jury's verdict be sustained legally? Is it possible? We're beyond, is it provable beyond a reasonable doubt? We're now into, is it possible? Yeah. So that's where we are now. So is it possible the jury had other motivations? Sure. Is it possible they convicted only on the facts? Yep. That's possible. There's enough facts, in my opinion, that would be legally cognizable. I'm just telling you how, as I as a judge would look at this on appeal. I can even do one better, by the way. I can even split the difference between the trial judge and the Court of Appeals. You want me to do this? Watch this happen, all right? I think the trial judge made a mistake. So, but I don't think it matters. So watch how this works, okay? I'm going to put on my trial judge hat. Now, I'm the trial judge, right? I think the trial judge made a mistake because I think the evidence was unduly cumulative. I think that too many witnesses said the same thing over and over and over. That's cumulative, right? It's beyond merely being probative. It's just saying the same thing over and over. We don't allow cumulative. You can allow new evidence in, but you don't allow the same evidence in again, right? That's the difference. Is the difference between new evidence and the same evidence again. Now, it's not merely like one thing that's going to do it. So like when we say cumulative, like we don't mean like, did another witness say like literally the same thing another person is? It's not that tight, right? It's not that tight. But there is an idea that we don't want to bring in multiple witnesses to say the same thing for the purpose of saying the same thing. It's cumulative. So I think the trial judge made a mistake. I think that the prosecution's case should have been more narrowly limited than it was. I think that it was determinable in advance, based on what the judge knew at the time, right? So I'm trying to do this not based on hindsight. I'm trying to do what he knew on the time. Based on what the judge knew at the time, I think he did not sufficiently constrain the prosecution witnesses. Now, so I think the trial judge made a mistake. Okay, so now I've done my trial judge hat. Now let me put on my Court of Appeals hat. Okay, so now I'm the Court of Appeals. And now I'm looking at this on appeal, and you come to me and you say, hey, Court of Appeals judge, Uncivil law. The trial judge was unduly cumulative. I'm like, okay, I agree with you. They're unduly cumulative. You know what the next question I get to ask is, right? You should know the next question because I've sufficiently teed it up for you, right? In my many discussions, right? So you come to me as the Court of Appeals judge and you say, the trial judge was unduly cumulative. I say, you're right. What's the next question? The next question is, assume it hadn't happened. Assume those witnesses weren't called. Assume they hadn't testified. Assume that this cumulative evidence was not presented. Could a reasonable jury still convict? And the answer is yes. Therefore, judgment sustained. You see how that works when I change hats, right? So I went from the trial judge screwed up to I'm not going to do anything about it as the Court of Appeals. It's nice putting on different hats. It helps you think. Was the amount of cumulative stuff so prejudicial? Was the amount of cumulative things so prejudicial to the defense that it undermined the principles of a fair trial? Nope. No. Trial judge was wrong, but it's okay. No biggie. Everyone goes home except Chauvin. Yeah. Yeah. So that's how that works. Yeah. This man is shaking. Am I? I am a little bit, actually. Now that you pointed out, I am shaking a little bit. I hadn't really thought about it, but you're right. I'm not sure why, but maybe a little cold. I feel fine. So how does it protect against cumulative witnesses? Well, as I said, right, the question is one of degree. The question is one of degree. The question is not, did cumulative stuff happen? The question is the amount of cumulative stuff so bad that it created a reversible problem? And in my opinion, the answer is no. It was a little much for my taste. But I mean, here's the thing. The trial judge gets a lot of discretion over their own courtroom. The trial judge gets a lot of discretion in terms of all these questions. A lot. It's not infinite, but it's a lot. There is a concept called abusive discretion, right? A discretion can be abused. So the question isn't, did he make the wrong call? The question is it abusive discretion? And even more to the point, even if it is, did it make a difference in a fundamental way? Did it impact this defendant's substantive rights? Was it unduly prejudicial? Not based on what I see, no. Not in my opinion. Not based on, yeah. So I think the trial judge screwed up, and I don't think it impacts the verdict. So, yep, that's what I think. Who decides how much is too bad in that way? The Court of Appeals. And the trial judge, for that matter. They both do. Yeah, the trial judge makes the initial determination, and then the Court of Appeals reviews for abusive discretion. So the trial judge makes how much is too much? Well, you know how they say tell to the judge? There's a reason they say tell to the judge. Judges have a lot of power. So who makes the initial determination on how much is too much? The trial judge does. What does the Court of Appeals do? They review for abusive discretion, reversible error. So that's how that works. That's who makes the decision. Those people. Yep. Can I give an example of what would be too much? I can give you a fictional example. We can talk about A Few Good Men. Not one of my favorite movies of all time. As we know. Kevin Bacon's character, the prosecutor in this case, called to the stand one of the people that were supposedly in the barracks at the time that this order was theoretically given. All right, so the idea is that Kendrick gave an order to the entire barracks, all right? And then, so this is the defense's theory. Kendrick gave an order to the troops in the barracks, and then he gave a separate order to a couple individuals, right? So, Kevin Bacon's character calls to the stand one of the people that was in there, one of the random soldiers, doesn't really matter. It's played by Cuba Gooding Jr. It's Kevin Gooding Jr.'s character. And he asked the question, ultimately, he asked the question, what was the order, right? So after faffing around for a while, he asked the ultimate question of what was the order? And Cuba Gooding Jr. says, the order was that Santiago was not to be touched. And Kevin Bacon says, great, dismissed. And then Kevin Bacon says, I'd like to call to the stand some other random guy in the barracks. And now, Tom Cruise's character could have objected based cumulative, right? Because Kevin Bacon himself said the reason he was calling it, because what Cappy said was, it's my understanding that they're going to call him to the stand for the purposes of, they're going to call all 150 people that were there about this order. And Kevin Bacon says, well, given the importance of the order, I think it's important to be clear. Now, what Cappy could have said was objection, cumulative, right? Which should have been sustained, right? The only reason I'm calling this guy to stand is literally to say exactly the same thing the other guy just said. The only reason, Kevin Bacon just told you the reason. I want to be really clear what the order is, right? So Cappy heads it all off of the pass by saying, fine, we'll stipulate to it. Which is like, great, we'll stipulate that all 150 people will say this if you stipulate that none of them were there like 10 minutes later when these other two people were. And Kevin Bacon says, great, and they say, great, and we're done, right? So that's an example from fiction of cumulative. Kevin Bacon was wrong. Kevin Bacon cannot call all 150 people to stand to say, what was the order? The order was not to be touched. What was the order? The order is not to be touched. It's like, we got it, you know? So that would be an example from fiction where things would be unduly cumulative. And so the question is, how close is this to this present reality? So, you know, all that good stuff. Yeah. So there you go. All right, I'm going to head out, guys. This has been a very entertaining stream. I hope you've enjoyed it. I've enjoyed it. You know, so for what it's worth, If even one juror is reported as saying they feared for their life, does that automatically throw out the trial? No. 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 Yeah, no. We're gonna presume. Yeah, we're gonna presume realities. There's legal fictions that are going on here, right? Legal fictions are, yeah, things are true. Can I disprove it? Nope. Not really. So I don't know. I didn't get to watch it. What happened the other day with the carbon monoxide test? It was not allowed in as evidence. It was not allowed in. There was a carbon monoxide test that showed that Floyd's carbon monoxide numbers were within normal range. I forget exactly what the number was, but there was a test that showed them within normal range, and that evidence was not admitted. It would have helped the prosecution's case a little bit more, but obviously it isn't enough. It does. If it had come in, you know, then it would help the prosecution, but they obviously didn't need the help, so it didn't matter in the end. Why only Chauvin? What about the other two cops? First of all, there are 3 other cops, not 2. And for reasons related to COVID, the judge severed the trials. Apparently, they were in the largest courtroom that the county had to offer. And apparently, they concluded that they could not, within CDC guidelines, get all 4 defendants in the room with their associated attorneys and support staff and so forth and so on. Now, I'd like to take note here that, one, presumably, unless the law is really, really specific about this, I would imagine the law is not that specific that we have to hold it within the courtroom. I mean, can we find another building to hold it in? I mean, maybe we can get a large conference room or, you know, like an empty arena or something. It's not like we have any problems finding space during the COVID shutdown. So do we really have to have it in this particular courtroom? Maybe we can borrow from the feds. Maybe they have a bigger courtroom we can borrow. I don't know. But yeah, because of COVID, the trial judge, over the strong objection of the prosecution, severed the trial for the other 3. So they're going to be charged at a later time, which I think is very unfortunate for the other 3, actually. The prosecution gave a hissy fit. I think the defense is more on a hissy fit. Because I don't think the other 3 are guilty, and I think it would have been more obvious in this light. But yeah, the other 3 are to be charged at some later time, because we concluded we couldn't get all 4 in the jury in the box at the same time. So for reasons of manifest necessity, I guess, we severed the trials. So that happened. Yeah, so that happened. Yeah, school gym or an auditorium somewhere. There's got to be somewhere we can borrow, you know? Yeah. The other 3 cops would have won it severed. I don't know. I think some of the prosecution's arguments, when the prosecution would not have been able to make the case they did if the other 3 people were there. They'd have to make a different case. They could not have presented the same exact case. They would have had to modify. I think it's doable, but I don't know who would be better off in that situation, but I don't know. And I don't think the other 3 are guilty. I don't think you can get to the requisite mens rea for the other 3. I don't think, because we're talking about mental state, right? So for Chauvin's mental state, he just has to have the intent to perform the act, not the intent to produce the harm, but the intent to perform the act. You're there. The question for the other 3 is, to be an accessory, they have to have the intent to help someone that they know is committing a crime, right? So the question becomes their subjective knowledge. And also, they were trying to help in other ways by warning and all the rest of it. So I don't really buy accessory for the other 3, so I think the other 3 would be not guilty, would be the best conclusion. I don't see them as accessories. I don't really think you can get to the requisite mental state of the intent, because they have to have the intent to assist a crime they know is occurring. Can you really get to that mental state? Not in my view. So I don't think the other 3 are guilty. So I will be interesting to see. It'll be interesting to see a couple things. One, will that trial still happen? I mean, presumably. But I mean, yeah. Maybe they'll offer them a deal. Maybe some of them will settle out now. Because Chauvin was the big fish, right? So maybe they'll settle it out for something and see, maybe someone will take it. I don't know. And maybe the state will lose interest. I don't know. And if they do go forward on all 3, it'll be interesting to see how that goes. But where I'm sitting right now, I don't think that the state can prove the mens rea. I don't think they're there. So, yeah. That's what I think. Will there be riots if they're acquitted? Probably. Yeah, probably. You know what's you know, what's probably sad is there probably is enough evidence to convict them, because the question is ultimately what is in the mind of those people, right? And also what their knowledge is. And it's a matter of just black letter law. And for those of you who are not familiar with the phrase, when you say something is black letter law, what you're saying is basically it's been written down in black ink, right? Or more to the point, it's permanent. It's like, it's not a controversial proposition. It is one of those like well-baked propositions when you say something is black letter law. So it's black letter law that if the jury finds that they performed the act, the jury can infer the requisite knowledge, right? So merely because they performed the act, the jury can infer the knowledge. So merely from them performing the thing, the jury can infer that they actually knew what they needed to know. So strictly speaking, as a prosecution, you don't even need to prove evidence. Now, of course they will, but strictly speaking, as a matter of law, you don't even have to prove evidence of their knowledge. You only have to prove that they did the thing. And then the jury can infer the knowledge. So super fun. So is there enough to convict the other three? Probably, almost certainly. Yes. Do I think that they should? No. Do I think that they actually had the requisite knowledge? No, I don't think so. But could a jury convict? Probably, almost certainly, yes. So we'll see how that goes, I guess. You know, I'm going to stop talking. I hope you enjoyed the stream. If you have liked it, please give it a like. If you haven't subscribed already, why not? You should subscribe. And did you know you can become a member of the channel? It's true, for a mere 99 cents. You too can become an Uncivil and help support the channel financially. I hope you appreciated the stream. It's been a lot of fun talking to you. I hope all is well. Cheers and goodbye.